All right, mic check, 1 2 1 2. What's up, everybody? We are back. It's funny because as soon as I went live, we got an email. Ah, all right, we are back with Fani Willis. Fani Willis. This case has gotten out of control, and one of the things I love about this case is the way everyone is like. If you're on the right, how they analyze the case and what they essentially say Fani Willis has committed perjury. Then you have on your left, you hear they say this is nothing. People have relationships and like so. It's wild to see how the reality of what we actually see on the screen is so different than how it's being reported in the news. Let me see. Hey, what's going on? Hey, what's going on? Let's go. Yes, let's go. Let's go. All right, so you guys know I'm like the king of recaps. I like to recap things so everyone understands what the hell's going on. So let me add this. This is Fani Willis. Now, again, this is going to be a recap before we go into what's going on today at court. Fani Willis is the DA of Fulton County. That's in Atlanta, Georgia. Now, she's been DA since I think 2021 when she was sworn in. Now, she's the one who had the big YSL trial, the rappers trial, and then she also had the Trump election interference trial. So essentially, she got in office and she's like, I'm going to indict former President Trump and 18 co-defendants. Now, for that, she needed help. So what did she do? She hired what's known as independent counsels or special counsels in some place, or special prosecutors. There's a whole bunch of different names for them. But anyway, they're attorneys, local attorneys, who, if the DA needs help prosecuting a case, you can get a local attorney, you pay them an hourly rate, and they'll come in and help you prosecute. So the attorney that she got was her boyfriend, Nathan Wade. Now, this is one of the contentions that we're going to have to figure out today. See, Nathan Wade was not only hired by Fani Willis to do this case, but he was allegedly sleeping with her. Now, their story is that their sexual relationship started after he had gotten a job and he was working. It wasn't before. So one narrative is that she hired her boyfriend, and her boyfriend, got, she was getting paid and all this other stuff. And the other narrative is that no, she hired an experienced attorney, and then all of a sudden they got into a relationship, because it just sounds better that way. TJM says, Nate says he'll ban you if you if you hate Kyle Rayner. Yes, that's the greatest Green Lantern. But so now we understand who these two people are. That's her special prosecutor, which she's paying something like $500,000 for, and this is the DA. Now, then in comes this guy. This is Terrence Bradley. Now, you say, who the hell is Terrence Bradley? Terrence Bradley is the defense attorney. Actually, he's the divorce attorney for Nathan Wade. So this was his divorce attorney who was handling his divorce. Now, Nathan Wade was getting divorced from this woman. That is his ex-wife. Now, and she's beautiful, to be honest, to be fair. She's gorgeous. But anyway, he's getting divorced from her, and he says that she cheated on him in 2015, so they're getting divorced. So that's who was divorcing, and that's where a lot of these documents came into. Now, for those of you who don't remember, when Nathan Wade and his wife filed for the divorce, their divorce documents were actually sealed. So nobody knew what was in the divorce. So the question started becoming like, okay, how did the defense find out all this information? How'd they find out that Wade and Willis were sleeping together? Who spilled the beans? TJM says, think the cell phone records are a game changer. Grain of sand makes them heat. Yes, the cell phone. We'll get to that. I haven't even gotten to the cell phone records yet, but we're still working through. So we'll get to the cell phone records. So this is who he's divorcing. So when people look at the divorce documents to see what's going on, and we're like, we don't know what the hell's going on. There's nothing going on here. We can't see anything, right? The divorce documents were sealed. Very rare and very, very, very. It's to be honest with you, it's shockingly rare that divorce proceedings are sealed. That doesn't happen. But in this case, it did. And they both agreed to it being sealed. But anyway, divorce documents are sealed. So this guy, now, all of this starts because this guy, who you're going to see on the screen right now, this guy, he what he did, Terrence Bradley, is he had beef with Nathan Wade. Now, remember, he was Nathan Wade's attorney and business partner. He had beef with Nathan Wade. So what did he do? Well, he then contacts an attorney for the Trump team. Her name was Ashley Merchant. She is gorgeous too. We got a lot of these gorgeous attorneys. But anyway, he contacts her, Ashley Merchant. Oops. TJM says, Nate, must be Jersey for a fish pump when there's a bombshell of old people are smoking. Yes. I got to get one of those. Oh, yeah. I got to get one of those monikers. So Ashley Merchant, who again, I'm going to say is gorgeous in this picture. It's a great picture of her. He now talks to her. Now, this is before everything even happened. He starts talking to her and sending her stuff. Like, yo, Wade is banging Fani. Because she didn't know any of it. She didn't know that Wade was banging Fani. So he's texting her all this stuff. Now, this is an important part to the story. What he is texting her is privileged information. He's texting her privileged information. Stuff that his client told him that was only supposed to be between him and his client. It's like, as a lawyer, you tell your lawyer stuff and they're not supposed to tell people. That's not what this lawyer did. He started texting all his client's secrets to this woman. Now, I'm assuming it's kind of like a honeypot scenario. Let me get these stupid chats. But I think it's honeypot. He sees this beautiful face. She's, hey, I like you, blah, blah, blah. He just starts giving up all the information. Oh my God. Thank you for coming back on this. It's been a circus. Yes. Between Rust, Emily D. Baker. Yeah, they got the Rusting going on. You are my resource. God, it's crazy. Well, thank you, Chi-Town. Nathan Wade cheating on his wife with Fani is something you would see on the Jerry Springer show. That's true, right? Like, this is who you're cheating with. So anyway, he's cheating on the wife. But now this guy is just giving up all of Nathan Wade's secrets. Remember, this guy is his attorney. So he's telling them all the secrets, right? Yeah, they're banging each other. Yeah, they're on vacations. Yeah. And telling them where all the bodies are buried. Why? He's got some beef with Nathan Wade. So she then gets all this information from him. And what does she do? She says, well, this is great. I can now try to disqualify Fani Willis because she's going on these elaborate trips with her boyfriend. Now, the disqualification, you're going to hear a lot about sex and all this other stuff. But I need to be very clear. The disqualification is on something very specific. Whether Nathan Wade and giving Fani Willis all these elaborate trips and all that stuff, whether Nathan Wade was essentially giving Fani Willis a kickback from the money he was making in prosecuting the Trump team. So that's what this is all about. Was he making any type of money through a kickback from Fani Willis? Now, when you say kickback, a lot of people think cash. They got to give you cash. But no, that's not how kickbacks work. It can be cash, but it also can be elaborate trips and vacation. Because if I give you $10,000 in cash, or I pay for your vacation, what happens to be $10,000, the result's the same. So it can be cash, trips, vacations, whatever. And in this case, they were alleging it's vacations. Thank you, Joan, for the $10 super sticker. Thank you so much. So this is where we're at. So this is the person who you're about to see on the screen again. That's the person who spilled the beans. That's the person who told it. This guy, the black guy. Now, he also said that Fani Willis and Nathan Wade relationship started before they were working together at the DA's office. Now, both of them deny that. Both of them say, no, the relationship started after we started working there. Okay, fine. We only have their words for it. But we have another witness who the defendant found. This is Fani Willis's best friend. This is her best friend at that time. So for those of you who don't know how this woman comes into the picture, this woman gets into the picture because she had to move from her apartment after she did the gang trials with YSL. She had to move out of her apartment because she was getting threats. So this woman said, "Hey, you can come live with me at my condo." But she wasn't living at the condo at the time, but she owned the condo. So they moved. So she moves into the condo. So Fani Willis moves into a condo, and she says back in 2019, Fani Willis and Nathan Wade had a sexual relationship during that time, a physical relationship, a romantic relationship. They were holding hands and all this other stuff. So now you had two witnesses, right? You have two witnesses, her and the Wade's former attorney. This guy both say that the relationship started back in 2019. even though Nathan Wade and Fani Willis were saying no, it did not. It started later. So that brings us to the issue of this guy. So the revelations that we have to deal with today. Oops, let me pull this back. So the revelations that we have to deal with today is, one, if all the information that he gave to Trump's legal team was privileged, then they wouldn't even be able to use it for the disqualification hearing because he wasn't supposed to give her that privileged information, right? He wasn't supposed to tell her all his client's secrets because he's trying, I'm assuming, to keep it real, I keep it real all the time. I'm assuming he thought he could try to maybe hit that. And he was probably in his mind, he's thinking, if I give her all these secrets, because you can even tell from the playfulness of the text messages when she was reading them in court, he thought that he may be able to get something out of this. Because why else would he just give up all his clients' secret information? It just doesn't make any sense. So I'm thinking he saw a pretty face. And now the reason why I'm thinking that is not just because she looks pretty and she's great. It's because of kind of his history. He's been caught sexually assault. He's allegedly sexually assaulted a person in his firm. A client came forward, he's sexually assaulted. This guy he's married because he has a wedding ring on. So I think he has an issue. He's maybe a sex addict or something, because all these women are saying he's fondling him and everything. And then he sees this beautiful woman and he got information she wants. So I'm thinking they played him. They played him with the classic honeypot. Hey, good kisses. Hey, you're my friend, you're my friend, you're my friend. And then all of a sudden, you're not really my friend because you give me all the information. Live from the Philippines, staying up for the late tea. If Bradley gossips confidential information and not privileged information, which you can, would it make a difference in helping him on his license? No. Bradley's probably going to lose his license because if the information is privileged or confidential, he's broken all these ethical rules. So he should lose his license for sure. She had to move out of her house to keep her innate secret. That's her to do with safety. All right. Well, that's it. I'm just reporting what they said. Nate, on the first day of the trial, Bradley claimed the bar told him the communication were protected by confidentiality. Yes, that's Rule 1.6, which you were talking about before. Something like that. Isn't that hearsay? No, because two things. It's the party opponent admission because we're talking about Wade and Willis. So what they said is not would be a hearsay exception. But number two, the reason why. So now I should break this down. Appreciate you, Nate. Great coverage as always. Thank you so much, Ethan. Just so I can break this down. So when Wade's attorney, I haven't even gotten there yet, but I am now you broke my concentration because I wanted to answer your question, but I wanted to answer it within this opening. Let me see. I don't think he ever truthfully considered NWA client, Nathan Wade a client. I think he did. Because as an attorney, you do favors for friends. So you don't go through all the formal client stuff. But the thing I wanted to say is, let me get that question again because it was based on this question. So explain it. So when he first tried to testify, he said that he was barred from testifying under Rule 1.6, which is confidentiality, which means anything you tell your attorney, even if it's not attorney-client privilege, it's supposed to be confidential. Especially, so for instance, if a client comes to my office and wants me to represent them, and then tells me exactly what's happening in that situation, and I choose not to represent them, I can't now then go and tell everyone else what that person just told me because they're protected under Rule 1.6 confidentiality because you're seeking legal advice. Now, if I go and tell other people, I've broken that rule, that ethical rule. But just because you told me and it's confidential doesn't mean it's protected under attorney-client privilege. Now, if it's protected under attorney-client privilege, then that means I can't testify to it at trial at all because the privilege is yours. So that's the difference here. So he was saying it was protected under 1.6 confidentiality, and the court said, well, confidentiality doesn't protect you against this type of inquiry under attorney-client privilege. The only thing that you don't have to testify to are things that are covered under attorney-client privilege. But I think this guy is screwed either way because he gave up privileged information, confidential information. Matter of fact, he even filed the documents that he knew, seemingly, based on what he testifies today, seems like he's going to know that it was false. So that's going to issue. Fannie may need you to be her defense attorney. I don't know. I don't think she's going to want me because I'm going to tell her, give it up, Fannie, give it up. Let me see. So they haven't started the court thing. This is standby for law of live audio. So we're standing by waiting for it. But that is it. So I'm just checking the feed to see if they started now, but they haven't started yet. Everybody's waiting. So So let me get back to. So I'm thinking. So I don't know why this guy gave up all Wade's secrets to this woman, but he did. But he did. That's essentially what he did. So now there are two big issues that we got to talk about. Likelihood of disqualification. I'm thinking it's more likely, but it depends on what happens today. But I need you guys likelihood. I'm thinking the likelihood is going to be pretty high. I'm thinking the likelihood is going to be pretty high from right now, because I need you guys to understand this from the perspective of the judge, and I'm going to try to explain it to you from the perspective of the judge. The judge is here to determine disqualification, but what's he really trying to look at? The judge here is trying to figure out whether Fani Willis got any type of financial benefit from Nathan Wade, right? And in the form of gifts and stuff, right? So that's the point, that if there's an appearance that happened, then she's disqualified from the case. If it's not, then she's not. So that's what we're looking at. That's the focus of this. But now the focus comes in a particular way. The focus of this is now Fani Willis and Nathan Wade have both said that Fani Willis didn't benefit because she paid back every single dime to Nathan Wade. Every single dime, she said, I paid back to Nathan Wade. So I didn't financially benefit from any of this. He was paid back. Fine, right? Fine. If you didn't financially benefit, if you paid back, fine. But when they ask for receipts or anything of substance like that, they don't have any receipts. They don't have anything. So the only thing the judge can rely on as proof is their good. Hold on, it's starting up. Here we go.
Thank you all. Please be seated.
I'll finish the explanation in a second. I think it's starting up. So right now, this is about Fani Willis's credibility.
Back on the record with 23 SC 1888947. If we could have counsel starting with the state identify themselves for the record for the purpose of today.
Adam Abadi for the state, Your Honor.
All right, and in order of the styling, let's start with former President Trump. I think we have Mr. Sadow on Zoom.
You do, Your Honor. Good afternoon. Steve Sadow for President Trump. We waive his presence, and I believe Ms. Little is also on Zoom. And
okay, thank you, Mr. Sadow. On behalf of Mr. Giuliani.
Alan Stockton on behalf of Mayor Giuliani, I think David Lewis.
So these are all the appearances of all attorneys. Don't forget, you got the 18 co-defendants attorneys there,
There we go.
and you got the
Mr.
district attorneys there. So they're going through all the attorneys who are there.
Mr. Meadows, and he waives his appearance.
Thank you, Mr. Durham. On behalf of Mr. Clark.
Attorney McDougall, Your Honor, and he also waives his appearance.
Thank you, Mr. McDougall. On behalf of Mr. Chile.
What happens is the defendants have the right to be there, so they're waiving their appearance. Why are we going to go there? That's why you're here now.
Thank you. On behalf of Mr. Roman.
Ashley Merchant.
All right, on behalf of Mr. Schaefer.
Greg Gillen and Anthony Lake on behalf of Mr. Schaefer, and he waives his presence.
On behalf of Mr. Floyd.
Morning, Your Honor. Good afternoon, Your Honor. Chris Kachuroff and Mr. Floyd. We also waive Mr. Floyd's appearance.
Thank you, Mr. Kachuroff. And on behalf of Ms. Latham. Anybody here on behalf of Ms. Latham? All right, I know before we'd had Mr. Cromwell, and I had not heard anything from him. I don't know if any other parties have as well, but
Your Honor, I believe Mr. Cromwell is in a deposition in South Georgia. That's all I know.
all right.
There's a Zoom participant, Mr. Cromwell.
Looked like he joined.
Okay, that's helpful to know. Mr. Cromwell, can you hear us? All right, well, we'll keep an eye on that to see if he does join us, and we'll take it up as it comes. So, just a few preliminaries. First of all, I'm a bit under the weather, so I'll try to speak up, but if anyone can't hear me, just let me know. I'll try to talk close to the microphone. But we are here today, the sole purpose of which is that at the conclusion of the hearing on February 16th, I announced that I'd be meeting with Mr. Bradley in camera to assess the validity of his assertion of attorney-client privilege. I've now been able to do that, and I also allowed Mr. Wade the opportunity to weigh in and respond as well. And after considering the testimony, not only in camera, but also of what came out at the hearing, I found that neither Mr. Wade nor Mr. Bradley had met their burden of establishing that the attorney-client privilege applied specifically as it relates
This
to
is
Mr.
crazy.
Bradley's
So that means
knowledge
there's no
of
attorney-client
any,
privilege.
relationship that existed between
So he could testify to
Ms. Willis
everything.
and Mr. Wade.
Oh,
And
they are
particularly when it wasn't
screwed.
established that his specific knowledge came about in furtherance of legal advice.
Thank you for the
So
super
having
chat.
made
super
that
sticker.
determination, I didn't see any other choice but to allow the parties to have an
Wow.
opportunity.
So
to
so they
explore
say
that,
he said none of it was.
that topic with him. There's
What's he gonna
really,
say?
in my
What the
mind,
hell's he gonna
it's
say?
that topic only. I think
Oh,
if there's anything else we've already
shit.
covered, I'm not going to do it again.
This is crazy.
With that, is there anything else?
Wow.
we need to cover
According
before
to
kicking that
Lee,
off?
the attorney coach, everyone is trying to clap cheeks. It makes sense that he's trying to get back at Wade. And hit the block. Hey, you probably are right. There she
Mr.
is
Bob.
right there. The picture I have of her looks better though.
I believe Mr. Wade was released from subpoena when we concluded his testimony the last hearing. So unless he's been resubpoenaed, and I have no knowledge of that.
Wow, this is going to be good
Sure.
because don't forget this guy
I
knows where all
think
the bodies were buried. He was telling,
Procedurally,
he's,
that
remember?
would be accurate.
He knows when they started.
so
He was his attorney. He was
At
his
this
best
point, I don't
friend.
see
So
a means where he would need
is
to be
he going to
recalled,
say that the relationship
and,
started
but
in
if it is,
2019 or
then
2020?
that is something you can take up.
If he does, they're
All
screwed.
right. Mr. Bradley, through his attorney, had informed me that he would be here today in person. I don't see him in the gallery. Do we know if he's out in the hallway? Okay. All right. If we could call for Mr. Bradley.
All right, here it is. Here it is. Oh, shoot. Thanks for the coverage. All right. Oh, I appreciate it. I appreciate it. Now, before he gets up there, remember what we're listening for. When the relationship started,
All right, Mr.
when the
Bradley,
relationship started. That's what they wanted to ask him. Mr. Bradley, when did he tell you the relationship started? Wow. Jersey Shore. All right. That's so funny. Who in the heck would hire him after? I wouldn't hire him.
NCE Bradley, BRADLEY.
We know what your name is. We know what your name is. We know you are.
Good afternoon, Mr. Bradley.
Here we go.
Good to see you. Sorry, under these circumstances.
Here we go.
I'm going to just go straight to where we left off before. Fani Willis and Nathan Wade were in a romantic relationship, correct?
Uh-oh. It just got real.
And it began at the time that they
Thanks.
were both municipal court judges, correct?
Objection, Your Honor, based on privilege. That would be covered in the attorney-client privilege.
Okay. Overruled.
All right.
I do not have knowledge of it starting or when it started.
He has no knowledge
Terrence,
of
you
when the
told me
relationship
that it
started.
started when they were both municipal court judges, though, correct?
That is incorrect.
You never confirmed in writing that it was instead of magistrate court, it was in municipal court when they started dating?
If you're speaking of the text message, you can go to that text message and you can read that text message, and I will explain the text message to you. But you and I did not have a conversation about when it started. You asked a compound question of magistrate court versus, you said it was magistrate court, municipal you said magistrate court conference. I'm sorry. And then you asked another question. I said, no, municipal court, nothing else.
I'm referring to a different conversation. I asked you, do you think it started before she hired him?
And I'm going to object. This was covered in the previous hearing where Mr. Bradley said he had no personal knowledge of the exact text that Ms. Merchant is speaking of and actually used in an attempt to refresh his recollection. And he explained exactly what he's explaining before the court. So this is repetitive and unnecessary. So I would object to asked and answered and relevant to this point.
All right. Perhaps we'll get there, but I think first Ms. Merchant has the right to draw his attention to the exact, potentially inconsistent statement.
Thank you, Judge. May I approach him?
So overruled.
This
You
is
may.
the text that he used.
Here, I'm going to switch this to another one, which has got better sound. Here we go. This one has a lot better sound.
And for purposes of the record, I believe, Ms. Merchant, you tendered, was it the entire text chain as an exhibit?
I only tendered a few of the texts, but I did give the state their courtesy copies last time of the exhibits.
Was this one tendered?
Over under
one
House
was not
witness being
tendered. All right.
declared.
And I'm happy to tender it.
Well, just
Well, he's already
take
an
it as it comes.
adversary, so
Whatever
We're
you.
at,
we'll see.
I think we're at 39.
I think he may go higher.
I will wait to mark it, but I think we're at 39. May I approach, Judge?
Meh.
I think 2-1. So she's approaching him. So what he's essentially now saying that he didn't say when the relationship started. He's trying to protect his career, obviously. So now she's going to give him the text messages to say what is going on.
All right. So Terrence, do you remember telling me that it started when she left the DA's office and was a judge in South Fulton?
I see the message there, but I don't recall. I do see that message, but I do not recall.
You don't recall texting this?
I look back at my text messages through that we've had. I see that message, but I do not recall that. No, ma'am.
And when I asked you if you thought it started before she hired him, and you responded absolutely.
Your Honor, I'm going to object as to the source of the information that Mr. Bradley
Well, she's asking if he said
gathered
it.
this from.
You got to
There's
ask the
been
source
absolutely
later.
no foundation, and based on the arguments at the last hearing, that a lot of this is based on gossip, innuendo, assumption, and privileged information. And at this point, Ms. Merchant has not provided a foundation as to how Mr. Bradley would have any information that she keeps referring to.
How does he know?
I
when
think
the-
that's. Go ahead, Ms. Merchant.
I didn't ask him about the source of the information. And under Rule
Thank you so
621,
much. Thank you
I
so
can
much.
impeach him with any inconsistent facts. This is an
That's
inconsistent
true.
fact. I can impeach him with any contrary facts.
Sure.
That's true.
This is a
Why would it
contrary
be
fact.
a relevant impeachment if he actually has no personal knowledge of this?
If he doesn't.
Sure.
have
So I
personal
think you have to lay that foundation then. So
Of
that'll be
why he has the
sustained.
personal knowledge of it.
Do you remember telling me that it began?
Well, that
That's
doesn't
still the
address
same
the.
thing,
I'm
yeah.
not, I was
Of
just asking
personal
if you
knowledge.
remember telling me as opposed to the
Okay,
text.
sure.
Do you remember telling me that it began?
Well, no, and then you're going into the substance of it,
Yes.
which we haven't
established why
determined
he
whether he actually
it.
knows
Yeah.
or how he knows.
It's tough.
You told
because-
me. In fact, you corrected me when I said magistrate court. You corrected me and said it was municipal court. Do you
Yeah.
remember that?
Same objection, Your Honor.
This is the exact same issue, right?
Well, I'm
Yeah,
asking if he remembers that. He hasn't answered that question yet.
right, but the relevance of whether he remembers it isn't established until we know how he remembers it or why he knows it.
I think the judge is being a little too tawdry here now. Because
Does
you
that
asked,
make sense?
well, she's
I guess
asking
not.
no, she's asking
Sorry.
the first. She's asking the first.
How he knows
question.
it? I'm just asking if he told me that.
Yeah, if he told
Right.
you,
So
then
I
you
wasn't
ask him
asking how he
knows,
knew
right?
that. I wasn't asking the source of that knowledge. I was asking if he told me that.
Yeah, if
That
he
was it.
told me, and then how do you know? How did you
That's
know it
the
was
point.
true?
It's how he knows it.
Right.
The source of his knowledge.
Yeah, he's
State would
lying to
contend
his
it's
career.
hearsay because it's gossip
It
and
is
innuendo,
hearsay.
which is what was indicated at the last hearing.
Well, it may not be hearsay. It may not be gossip. We haven't really gotten there yet. We don't know how he knows what apparently he's telling her. And I think we need to
Exactly.
figure that out before we can go any further.
Yes. And if the source of the information is a witness who've testified, then it's not hearsay. So when did the relationship start?
I cannot answer that.
When was your first knowledge of the relationship?
Objection, Your Honor. He's already answered that question multiple times today. He said he has no idea the timeline or when it occurred. That was one of the first questions that Ms. Merchant asked.
I didn't ask when. I asked
No,
his first
his
knowledge.
first
He testified
knowledge,
he has
yeah.
knowledge that they had a relationship. I asked him when he first got knowledge of that.
All these objections because you don't. Want,
Okay.
you want,
So
you
if
don't
the
want to
question
answer
is,
that
when did
question.
you first get knowledge? I think we can start there.
That was the question. Yes.
All right.
Thank you. When did you first get knowledge of their relationship?
I've said over again that I didn't have any personal information where I could personally say when it started. I've said that time and time again. So I don't know when the relationship started.
Okay.
And that wasn't my question. So my
Mm-hmm.
question is, when did you first gain knowledge? I didn't ask the source of the knowledge, didn't ask you to comment on the validity of the knowledge. I asked
Well,
when you first had knowledge.
We'll get to the how, Mr. Abadi. So I'll
Yeah.
note the objection, overrule it. You can
And
answer
I-
that.
and just for the record, and I appreciate your honor. But he said he had no personal knowledge, so he had to gain the knowledge not from hearsay.
He could have gained it from
Sure.
Mr. Wade.
Well, I mean, most of us learn things from hearsay. The question of whether it's admissible, right?
That's true.
And that's
Yeah,
what we got to get to. So
because you don't even know if it's hearsay or not yet.
I apologize.
When did you first get knowledge? I'm not qualifying what type of knowledge. I'm just asking when you first knew about the relationship.
If he says before 2022,
I don't know how to answer that.
If he says
I
before
mean,
2022,
so
he's screwed. So he can't say before 2022.
I can't give you a date if you're asking for a date.
No, now this is
If
her.
you're asking me, how did I get the knowledge?
No, she didn't ask you that. She said,
It
when
would
did
have
you, when did you
come
know?
directly from my client.
Right.
So help me understand.
I think you say you can't answer that question. You don't know the date. So that's the answer to the question.
Yeah.
But
you don't know the
I said
date.
that 5 minutes ago.
We have to make it clear.
Yes,
All
sir.
right. Next question, Ms. Merchant.
So you don't know the specific date.
No.
Was it
Do
before?
you know if it,
if
can
it was
we narrow
before
down the time?
2022.
Was
That's
it,
what
did you
wanna know.
gain knowledge in 2019 of this relationship beginning?
I'm going to object to this line of questioning as he said he does not know
Sure.
when he
The exact
gained
All
date.
right.
He doesn't know the
Overrule-
specific
That's
date.
fine, Ms. Merchant. I think
Yeah.
I'm overruling that. I think we
Of
can
course.
try to see if
Now
we can narrow it down based
narrow it
on
down.
goalposts.
Now you're
Thank you.
2019, 2020, 2021.
19, I would probably say no. I mean, I don't have anything that
Thank you so much.
I'm
She's asking bad.
there wasn't a
questions, but
specific date. There wasn't
we're not asking about a
a
specific date.
football game.
Did
There
you
wasn't
know
something
about it
that I can
before
attribute
he was hired
to
at the DA's
him
office?
telling
That's what she
me
wants to ask, but she's asking around it.
whatever. And so you're asking for a date, you're asking for a year, it's still a date.
I'm not asking
And
for a
at this
date.
time, I am telling you that I do not have the date.
Let's try this then. So you received a contract from Miss Willis, January 2021, correct?
Can I see the,
Yes,
yes, I think so.
Exhibits are, I think, okay.
I think if it was from the exhibits, I think it was 21, yes.
And I
Okay.
don't want to belabor the point. We did those
Yes.
when you were here before.
Yes,
If those documents that you looked at last time
yes,
said January 2022, that's okay.
21. I
I'm
didn't,
sorry, 21, you're right. Thank
and
you.
it was, I think, renewed in 22.
It was, yes. So the contract date was, that we have in the record is January
Merchant,
25th,
you
2022.
gotta be asking better
So using
questions.
that
Come on.
date, at that point, had they begun their romantic relationship?
Of
Question.
2022,
January 25th, 2021, I'm sorry. When you got your first contract?
Were they having a relationship? That's how she get to it. That's a good one. Because if he says yes, that means they're lying. If he says no, then he's lying.
I don't recall.
I can't answer it.
I don't
knows.
recall any
doesn't wanna
specific
say yes.
dates.
You didn't ask a specific date. We're not asking for
No,
a
ma'am.
specific date.
You remember when you got that contract though, correct?
I remember I had the contract, yes.
Okay. And you told us last week, or I guess it was the week before now, you told us that Mr. Wade brought you that contract, essentially told you about that contract.
He's
That
feeling
is
the
correct.
pressure. He's feeling the pressure.
So Ms. Willis is not the one that brought that contract to you directly. It was Mr. Wade.
That is correct.
At that point in time, they were already engaged in a relationship though,
I'm going
correct?
to object, Your
I
Honor.
can't say that.
Characterization of what Mr. Bradley just said. He just said he does not remember. There's nothing specific.
He doesn't remember the exact date. And I think the question now is to reference it or tie it to maybe some other event that he might remember.
I agree with
Yeah.
Your Honor. She asked that specific question. He said he does not remember any specific dates after signing the contract. That's exactly
Sure.
what he just said. This is
All
asked and answered.
I know, and we're getting to the end of it. So, Ms. Merchant, you don't have much more to pull on here, but he answered that last question. So what's your next one?
And Judge, I didn't hear the answer if they were in a relationship January 25th,
Mr.
2021.
Bradley, do you recall the question?
I recall the question, and I can't tell you accurately whether or not they were in a relationship at the time. You asked me about him bringing me a contract. I said he did bring me a contract, and that is accurate.
Do you remember
Yeah, she's
prior,
blowing
do
it.
you remember knowing Ms. Willis prior to her taking office as the DA?
I had very little contact with Miss Willis. I knew her through my business of coming down to Fulton, if that's what you're asking. Yes,
You knew her through the business. So you had met her prior to your contract.
I'm going to object to relevance at this point as to why we're here today.
Sure.
Judge, he doesn't remember much of anything right now. And so I'm trying to create a timeline to hopefully piece this together.
All right. Well, I'm not seeing really the likelihood that that's going to have any success, I'll let you ask a few more questions. But if he doesn't have a date, then I don't know that you're going to be able to create one today.
Okay, thank you.
Well, don't forget, you got like 16 other attorneys there who will probably chomping at the bit to get up there, because I would be. Because you just
So
got
the
to ask
time that
them.
you had this contract from January 2021
She just
until
doesn't know what
January
the question to ask.
2022, did you come in and out of the DA's office?
Yes.
Okay, and so were you able to witness Mr. Wade and Ms. Willis interact during that time?
I'm going to object. This has been asked and answered. It was addressed at the last hearing about Mr. Bradley's access to and from a specific room to pick up files. And Mr. Bradley said that
Sure.
he rarely saw them together, but this was
Yeah,
answered.
I think the only avenue that was closed at the last hearing was his personal knowledge, potentially
Oh yeah.
through.
Oh yeah.
Well, actually, no. If he testified, it was that he had
confused
no
with SF.
personal knowledge. It's knowledge that conveyed to him that was cut off at the last hearing. That's really the only thing we hadn't been able to explore, unless you correct me if I'm wrong,
Knowledge that was conveyed to him by,
by somebody else. That's that he claimed at the time was privilege. I found that it's not. That's what we're here to explore.
okay.
That's the question that she needs
Um,
to be asking. But how do you get to that question? You see, the judge is literally saying, this is what you need to be asking about.
Do you remember telling me that not many people knew where they met?
I'm going to object as to relevance, as to his personal knowledge, which is what 602 requires.
Yeah, I mean, we're back to the same point, Ms. Merchant.
His personal knowledge is what I'm asking him what he told me.
But he hasn't yet told you how he knows that. And so unless you can establish why he should be testifying on this at all, then there's no relevance.
And I don't know how he knows that. That would be
Then
the
ask
next
him.
That would be the next question.
But
But
ask him how he knows it.
I first have to establish that he said that.
No, you don't. You could go the other way around.
Yeah, yeah. See, the judge. This is crazy. The judge is like literally, this is how you do it, you
When you
idiot.
told me that it started when she left the DA's office and was a judge in South Fulton. Where did you gain that knowledge from?
There it is. Finally, the judge is like, this is the way you do it. Just do it.
Oh, I'm going to object because his testimony a few minutes ago that he did not recall making that statement.
All right, I'll overrule that. Mr. Bradley, answer the question.
There
if
it
you
is.
can.
See, the judge is like, finally, you asked the question he can answer.
Repeat the question.
When you told me that their relationship started when she left the DA's office and was a judge in South Fulton, where did you obtain that knowledge from?
30 minutes for her to say that one freaking question. That was the question.
I was speculating. I didn't have a.
See, finally got the answer. What? Now you go through all the other text messages. When you told me this, where did you get this information from?
No
You
one
told
told
this,
me I was
where'd you get this
speculating.
information from?
No one told you that?
No one told me that.
You
You were
just made it up.
speculating based on things that had been told to you or things you had observed?
So I'm going to object as to the nature of this line of questioning because the witness has made it clear he was speculating as to how or what he knew. And if it's speculation, it's inadmissible before this court.
All right, but the motivations
Motivation
for his
behind
reason
it.
for speculating would be
It's
admissible,
good.
so I'll
Yeah,
overrule
so-
that.
Yeah.
Thank you, Judge. Was this speculation when you told me that? Was that based on things that had been told to you and things that you had witnessed?
There it is. Why
I
speculate?
never witnessed anything. So, it was speculation. I can't tell you anything specific if that's what you're asking.
Tell me anything specific as to why you speculated about that?
No, this was however many years ago. I mean, I don't recall, but no, I don't.
Did you have any reason why?
I don't know if speculation is lying, but
Well, let me just
Did you have
show
any
me
reason
where
to
in this
lie?
text it says you're speculating. or
you didn't
know.
ask me if I was speculating
No,
or guessing.
You said it.
I didn't ask you, but tell me
You
if
said
it
it.
says anywhere here that
No,
it's
it-
speculation.
If this is the same one that you just showed
You
me, it
do
does
it.
not.
Now she's
And you're
getting into
welcome
a
if you
flow.
need to look at your text.
Hit 'em
is
with
there
the
anywhere
paperwork.
here
That's what you
that
said,
indicates
right?
that you didn't have knowledge of the
No.
relationship?
And I'm going to object. The line of questioning Your Honor directed counsel to explore is where he got the knowledge. She's explored that. He said it's speculation and he didn't get it from any source other than his own speculation.
Sure,
So
I think we're flushing that out.
Yeah.
And
Now
I
the
think
DA's
it's her
office,
right
that's
to
those objections. They're objecting
have a
because they
little
don't want
leeway
him
on
to,
this
they don't
if
want him to
he's
say anything
an adverse
because
witness.
they know how bad this
And
is for
Judge,
Fani Willis.
These speaking objections are clearly coaching the witness because he's regurgitating.
Your Honor, I
What-
object and take offense to that comment. I'm objecting based
said
on
he's
the
coaching
law.
the
and I'm-
witness.
And I'm making a record for the court.
All right.
So I take offense to that comment. It's not the case.
All right. Well,
Getting
I think we
testy.
can start with objection, the grounds, and the rule number, and then if I need more, I'll ask.
Thank you.
All right.
Thank you. What did Nathan tell you about the relationship?
Objection, hearsay.
Nathan has testified. It's
Yeah.
not hearsay.
That's true. He's
It's
testified
still
to it.
hearsay. It's an out-of-court statement being brought in for the truth of the matter asserted. So hearsay.
Judge,
Yeah, this would be for impeachment by contradiction, which would
Thank
be an
you.
exception to the hearsay rule and admissible as substantive evidence, and the
Yes,
privilege
sure.
issues are overruled.
thank you, Judge.
Yep, there it is. He's got to tell her now.
Well, I think you just overruled the privilege objection, but we don't know when he's talking about. So we've already established in December
Right.
2018.
I'm confused. about
Sure.
yours.
And that's something I covered in the in-camera hearing, and I'm, based on what he told me in that in-camera hearing, I don't believe any statements to this effect were covered by privilege.
No, the
And
judge.
Judge,
the
I
judge
just
can't.
want for the record, because sometimes the record doesn't reflect where people are looking, and that when I ask a question, Mr. Bradley
judge
is
can't appeal.
looking at Mr. Wade and his lawyer to wait for them to object, and they're clearly interacting somehow in the court. So I just want the record to reflect that because it wouldn't otherwise.
It's there now.
Thank
A question was put to you, Mr. Bradley.
Judge, one of my lawyers is sitting right in the back,
We
that's
don't have to go down
behind.
that rabbit hole. You can look wherever you want.
Yeah, and I never
You can
looked
look
at
wherever you
Mr.
want.
Wade or his attorneys. That sounds kosher.
All right.
Yeah, he's coaching
Mr.
that.
Bradley, question
He's
was
like,
put
this
to
is
you.
how you get there.
Repeat the
Pause.
question, please.
Yes, so I showed you, or I asked you, I'm sorry, the last question.
The
I
judge
asked you
got her on.
was,
got her
what
moving
did
now.
Nathan Wade tell you about the relationship?
Come on, girl. You got it. What did he tell you?
Objection, Your Honor.
And that's already
Overruled.
been ruled upon.
Yeah, go ahead. Now, see, they don't want to. They don't want to answer this. This is the question, people. Come on.
I recall him stating that at some point they were dating. I can't tell you what date that was.
I don't care about the date. or
It was
time.
made in confidence. We were in the back of our office. Our offices were the only two in the back. There was no one else present. That is all I can tell you at this time.
One time?
One time.
You only had a conversation with him one time about the relationship?
Objection, asked and answered.
No, I think that's
No, no, that's
clarify
false.
for
Yeah,
a thorough and
clarify
sifting
follow-up.
cross. Ms. Merchant.
He's being.
I do not recall any other time that he mentioned
Now you start narrowing it down.
uh,
Was it 2019?
that they were in a
Was it
relationship. No.
2020? Was it 2021? Like you start narrowing it down. All right, so let's get years. Was it 2021?
Okay.
Was it in 2020? Was it in 2019? Come on.
So you talked about this one time,
Start
and you
narrowing
said
it.
you don't know when it was though, correct?
That is correct.
Was it before Mr. Wade, before you got the contract in Fulton County? Let's start with that.
I do not recall.
Okay. And how did it come up?
Say again.
How did it come up?
I do not recall how it came up. It was in the back. I know where it occurred. In our offices in the back. I can't tell you what we were discussing prior to that.
So he just don't know when it occurred.
Okay.
No year, no decade, no nothing. He just doesn't know when.
Did you receive an email from me on January 6th with a motion attached?
I think I did. Yes. Yes. I know. I received I don't know if the date is January 6th, but
Not
yes, I
really.
received that.
Okay.
Yes.
It's
So you remember
funny. He
receiving
can,
it.
but
Yes.
he can't
What's the date?
because the in camera.
Um,
So
And you reviewed it, and then you
let him flush
and I
it out
spoke
now,
about it.
So you really can't use it.
Do you recall that?
He can only use what's on the record.
Did we speak over the phone or are you saying through a text?
That's what I'm asking you. If you
I
recall
can't
speaking-
remember whether it was text to phone or
But you recall us speaking, one way or another.
one way or another. Yes.
And where I was trying to confirm the facts in that filing.
I think I remember there was a line of about the accuracy of how how much money
Yes.
that
that's a very
my
good question.
office,
Yes.
the law office,
Was it
Terrence
before we
Bradley,
filed the divorce?
have received. And whether or not that was going to be in
Damn good question.
the motion or not.
There wasn't a discrepancy. I had kept that out. You asked me to step back in, correct?
I recall you, that may be accurate, yes.
And you thought, because you thought it might be suspicious if you were left out of the motion.
No, I think we discussed that it should reflect the accuracy, because the accuracy was that I received, I had a contract and received 74,000. And I think you had put in there that Mr. Campbell had received a certain amount, and then you also had put in there that Mr. Wade had received a certain amount, but there was not anything in there originally. And I said that it needed to be accurate. I needed to be accurate as far as that I had received 74,000. That's
Right.
correct.
Because you did not want anyone knowing that you had talked to me.
I'm gonna object this to relevance.
Be biased. Overruled.
I wanted you to be accurate as far as the accuracy of our message or your filing.
Okay, so that was your interest was in accuracy in the filing.
I didn't reach out to you and say, send me a copy of your motion.
Right.
I didn't reach out to you to say that that I'm going to be in your motion.
Right. I asked you to review it for accuracy.
For accuracy. And I just stated that it was inaccurate.
And the inaccuracy that you pointed out was the thing about or how much you had made.
That was the inaccuracy that I saw that jumped out, was the fact that I saw that I was left out when you had put the firm, the money wise. I did not, when I responded to that, it was for that specific reason.
Okay. And I agreed I would put that back in, that section back in, and I did.
Correct.
I did put it back in and I sent it to you again.
I don't recall getting a second email from you now.
But you were happy that I put it back in, or that I agreed to put it back in.
I'm gonna object this to relevance.
Yeah, we need to get to more material aspects.
Yes, Judge, I'm moving along, I promise. So you did ask me to put that back in.
Again,
Well,
asked and answered relevance.
well, he didn't answer that last question, so overruled.
You did, can you confirm you did ask me to put that back in for it to be accurate?
Yes, that's correct. I said that, yes.
Okay. And then I asked you if everything was accurate and you said, looks good.
Just so everybody understands, in the motion, he said
Correct.
that they were sleeping
I
together
recall you
before.
asking that, but the looks good was applying to the accuracy of the 74,000. That's it.
So when you reviewed the motion and you specifically pointed out that one thing that you found inaccurate, you didn't point anything else out that you found inaccurate in that motion though, correct?
No, I did not.
And that motion alleged that their relationship began when Miss Willis was in municipal court.
If I can reread the motion, but I don't recall, but if that's what it says.
She's asking.
But I did my saying that it looks good was when you put back in the 74,000 into your motion.
Okay. And that wasn't what I was asking. What I was asking is, you didn't tell me that there was anything else inaccurate in the motion though, right?
Yeah, he's running his own.
But I didn't state that anything was accurate other than the 74,000.
Now, when I told you that I had this motion that I was preparing. You asked me to send a rough draft.
No, that's incorrect.
I approached Judge.
You may.
So now she's going to impeach him. So
They're
she's
not page numbered. It's January 6th.
I just, yeah.
Yeah. of course.
so you guys understand she's trying to get
I can show
around
you
it. So
all the text.
she's trying to say, listen, I gave you this document that had all these allegations when they had the relationship. You checked it, you looked at it, and you said, hold on, the only thing that's wrong was how much money I made. Everything else is right. So now if that's true, then she's essentially getting him to testify that yeah, the relationship started before 2022. That's what they really want to get out of him. The relationship started definitively before 2022. This is more interesting than the arrest case, huh? Yeah, this one has sex lives videotape. He prepares an unprepared, extremely unbelievable to me. Yeah, of course. You don't recall.
We had been talking, you asked me to send you a rough draft, and I told you, okay, but I didn't want it to be leaked before I filed it. Right?
That is correct. That is correct.
So you're the one that asked me to send a rough draft.
He doesn't want to answer that because he just said he didn't ask her for anything, remember? Now he's got caught up in this little lie.
Yes, that's correct. That's correct.
That was at 10:08 on Saturday, January 6th. And then
Damn, he lied. He
got
got
an
caught in a
email
lie
from
right
that
now.
rough draft.
Some bullshit.
at 10:25 that same day, correct?
Damn.
Yeah, yes.
If you need to look at it, I can.
If it says 10:25, then I know you sent me an email.
You just don't forget you just testified, guy, that you didn't
I'm
ask
gonna
us
object
anything.
just to ask and answer. We've been through the fact that she sent him a copy of the motion, whether he specifically said rough draft or not, and then asked about the accuracy. He's explained his answer, and I've object to ask and answer. So
Understand, Mr. Vaughn. We're getting there. Overruled for now.
And then I responded when we were talking about that footnote that we were just talking about. I said, I took it out, but I can add it back. And you said, yes, add it back. You remember that?
I answered that, yes.
And then I said, anything else, anything that isn't accurate. And you responded, looks good. You recall that?
Let me see the,
And there, I don't know where the exhibits are, that were admitted.
The judge is waiting for him to say one thing because the judge knows what he wants.
it says looks good, but as I stated before, I was responding to you putting me back into the motion for receiving $74,000 in a contract.
This says, you said, yes, add it back. And then I said, anything else, anything that isn't accurate. And you responded, looks good. So you weren't responding to put it back in.
Your Honor, I'm gonna object.
I know.
This is not his motion. He wasn't the affiant of the motion or verified.
Overruled, Mr. Body.
Talking about his personal knowledge.
I've said
No personal knowledge.
twice.
Overruled, Mr. Body.
I've said twice that the looks accurate was, or I've said more than twice, was for the 74,000.
So he said,
You remember telling me about
he's lying.
Nathan and Fani coming to your office and spending time together at your office?
No, I mentioned, I do recall testifying on the 16th that she had come to our office.
Yeah.
And that was before she was elected as district attorney, correct?
I recall that that was when she was district attorney. Because I said that there was a meeting held at my office.
And who was at that meeting?
Now, I can't tell you that. I don't recall.
But you know, Miss Willis was there, Mr. Wade was there.
It was at our office. Actually, Miss Willis was there and there were other people there. Mr. Wade was not in that meeting. He was in the back. I wasn't even in that meeting.
Why did she hold it at your office then?
I have no idea.
You also remember telling me about them spending time together at her law office before she took her job.
I don't recall. Do you? I don't recall. Do you have something to?
Well, what I'm asking is, let's back up a sec. So Ms. Willis rented a law office from the Evans firm, or Andrew Evans and another lawyer, I think Stacy Evans. You have knowledge of that, correct?
I'm gonna object to hearsay.
I'm going to pause it real quick just for one quick thing. If he commits perjury in Fulton County, who's going to prosecute him? Right? So this guy, I think, is very fearful. He's cut the DA and is essentially committing perjury and all these essays that he's committing. I think he's got a lot to fear. Let me continue to play. But understand, he may be a little worried about that.
If
Well,
How does he know the information? That would be the correct question.
okay. Ms. Merchant?
I don't really know even how to respond to that. Hearsay. I'm asking if he knew that she rented.
Yeah,
offices.
he may have been there. He may
Right.
have, may have seen a business card or something at some point. I think you can answer that.
I've never been to Miss Willis's office when she was in private practice. I've never dealt with where she rented. I didn't even know where her office was. So
Do you remember though, knowing that she rented an office
yes,
from the Evans?
yes,
You did know
that's,
that.
that,
Thank
that
you.
is correct. Yes.
Okay. And do you remember telling me that Mr. Wade and Miss Willis
I don't
would
recall.
rendezvous at that office?
I'm gonna object to, again, hearsay as to how he knows that information. He said he has no personal knowledge. And
He did
just-
not say he has no personal knowledge, Judge. He hasn't even answered it.
No, he said in general, he had no personal knowledge. So it's not been established the source of how he would know this because he said he's never been to her office.
All right. Ms. Merchant, if you, I know you're trying to impeach him by a prior inconsistent statement, but unless you can first back up and show why each statement is actually something that he had knowledge of, I don't know if this is going to be relevant.
And Judge, I'm not even there yet, but again, that a speaking objection. And so now I would anticipate what our response is going to be next. I didn't ask anything that was objectionable, but these objections are coaching the witness. I asked if he had knowledge. That's it. I didn't ask, did someone say this to you? I didn't ask, what did this person tell you? I asked if he knew.
Well, no, you're asking if you had knowledge, and then you say of something specific. So,
Once I get an answer to that, if he has knowledge, then I will follow up with where that knowledge came
all
from.
right, well, let's try again.
See, the judge.
So
just
my
asked me to
question is, do
say-
you have knowledge of them meeting at that office?
Objection, foundation.
Okay, all right, overruled.
Do you have knowledge of them meeting at that office?
I have no personal knowledge if that's what you're asking.
I didn't ask that yet. I asked if you have any knowledge.
Objection, that would be
Oh,
hearsay.
Overruled.
Not if it came from
We
Mr.
don't
Wade,
know where it
Judge.
came from. So he
Yeah.
said, how do you
have
know,
knowledge,
Mr. Brown?
Then how do you have the knowledge? That's the foundation. So the judge is
How do you
right.
know?
Any knowledge that I would have received would have come from my client at the time.
Okay, so you had knowledge of this place that Miss Willis worked. What did you know about them meeting at that office?
Now, what did you know?
Objection,
How did you know?
hearsay.
It's not hearsay,
Overruled.
Judge.
Oh, yes, he's right.
How
he's
he
right.
knows it, and then you ask the next question.
All right, he's already asked the next question.
Yep. I was gonna-
Can you repeat the
gotta
question?
repeat it,
Yes.
yeah.
How do you have knowledge? What knowledge did, well, you just told us. You told us Mr. Wade told you. So tell us what Mr. Wade told you about Miss Willis and Mr. Wade meeting at the Evans office.
He doesn't want to say.
Objection, Your Honor, privilege. This clearly covers the time after December 2018 that would be covered by the privilege.
Yeah, overruled.
The defense is not guilty. There it is. What did he tell you? He's afraid to
You
say.
recall the question, Mr. Bradley?
I do not.
You re-asked the question, Ms. Merchant.
He's
What did you
afraid.
learn from Mr. Wade? Because we've clarified that's where you learned it from. About Mr. Wade and Miss Willis meeting at the Evans office together.
What's gonna happen? What can he say?
I'm gonna object to asked and answered. He's testified. that
He hasn't answered. We haven't heard an answer.
He testified he had one
He's like, "I
conversation
can't
with
say
Mr.
it!"
Wade in the back of his law office.
No, and his
The
answer
Lord
may
is
change.
screaming,
So
please,
overruled.
Office,
please,
what-
just,
how to
just don't
answer the
let him
question.
answer it. Don't let him answer it. Here it is. It's on you.
I can't recall what the conversation was. I do
remember. The good old I don't remember.
recall knowing that that he would go down to the office or had been down to the office, but I can't tell you in what capacity or when or any of that. No.
Mr. Wade told you that they had sex at that office, though, correct?
I don't recall him stating that, no.
You don't recall
No.
it. So it's possible he did say that. You just don't remember one way or another?
I do not remember him saying that.
Impeach him. Impeach him. Do you have the text message? If you got a text message, impeach
Do you
him.
recall that he had a garage door opener to either a house or a condo or something like that of Miss Willis's?
I've never seen a garage door opener. I've never been to Miss Willis's house. I've never been
He's
to,
not answering
and I'm
the
trying to
question.
explain.
He's
I've
answering
never
another question.
been. So no, I do not have any personal knowledge of him having a garage door opener. Yes, ma'am.
I didn't ask if you had personal knowledge, like as in you saw it. Do you have any knowledge at all from Mr. Wade or any source that he had a garage door opener to access one of Miss Willis's residence?
And I'll object to any source as to hearsay.
All right, depends on the source.
Yes.
Overruled.
So did Mr. Wade
No,
tell you?
no, I don't have any knowledge.
So he had no knowledge. All right.
So when you told me that, did you just make it up?
There's the impeachment.
Do you have something that shows that I told you that?
Yes, when, well,
Impeach him now.
we're going to go through all the texts we can.
Yeah, show him the
but do you-
document. Come on,
So was that made up
Ashley.
though?
No,
I'm
I
gonna
just-
object because I
I
don't.
don't
show him the damn
recall him
document.
having.
Come on, you got it right
Judge,
I'm gonna
there.
object under 106 is the rule of completeness. I don't have that text message or any text messages that indicate that, Your Honor.
And I don't have, if it was a text, we had that conversation. I actually think it was when he was on speakerphone and Mr. Merchant was there, but I'm not sure. But I mean, if I'm asked to qualify exactly where that's from, I would. give it.
Okay, so
Yeah.
rule of completeness would be if you need to introduce other text to show the context. If you're saying you
That's
don't
true.
haven't seen a copy yet, then I think Ms. Merchant needs to do that before you can
And I don't
decide your
have,
next step.
and that's what I was asking him. If that was something he just remembers making up. If he doesn't, then that's fine. But
She referenced text messages and started to go into her packet of papers.
Sure.
That have text.
So you don't have a
messages.
text message to that.
I would need some time to look through and I don't
If you
remember
know
if I
you're
have a
gonna
text
ask
to
him,
that or if
how
it was
do you
during a
not know?
conversation.
That
It was
should
one of those.
automatically be there.
Well,
And
Come
I'm-
on.
he has now said that he has no knowledge. So on to your next
Yeah,
question.
you lost that. She just lost that.
Did Mr. Wade
For
tell
not
you about the
being
trips
prepared.
that he and Miss Willis took?
No,
You got to have that in front of you.
You
She
have
just
any
says
knowledge
no.
of the
Here it
trips
is.
that he and Miss
Said.
Willis took?
Objection, hearsay.
Overruled.
I do now.
Okay, but you did not before this proceeding?
I did not know until you text that you found that in the deposition of his divorce.
So he
I
didn't
mean,
know they went on
not
trips all of a sudden
deposition,
until
but
she
something
told
from
him.
his divorce.
She told him about the trips now.
And when you responded, doesn't surprise me, they took many trips to Florida, Texas, California. Those are your words though, right?
I'm gonna object. That's the relevance. He said he did not know and he actually learned from Miss Merchant the information.
But now she's got
He
to
said he learned about certain trips from Miss Merchant.
Okay, you can tie it down, but
Yeah.
Thank you.
we'll
He said he
see.
had no information about any trip that Miss Willis and Mr. Wade took. That he learned it all from Miss Merchant. That was his testimony.
Sure.
She's not asking.
Judge, I'm
you to-
Maybe
allowed-
the conclusion we
Scalpel.
reach.
Get a
I think she
scalpel.
can ask more than one question though.
Yes, get a. She's got to
All right, Ms.
scalpel this
Merchant.
in.
And if
Come on,
Judge, just
Merchant.
so we can be clear, if he said more than one version, that's all relevant. We're allowed to talk about the different versions that he's told.
All right, I've overruled the
Thank
objection,
you.
Ms. Merchant.
Yeah, go ahead, Merchant. Go ahead. Come on, you got it.
Do you remember
He's with
telling me that it didn't surprise you that they took the trips that I found in the divorce file because they took many trips to Florida, Texas, California? And then you told me that they took the trip to California when she moved her daughter there because she failed out of FAMU. You remember
Say
that?
Spank him. Go ahead, girl. Get it.
I don't recall that, but if,
Now you better be ready
I
to hit him
don't
with those
recall.
text messages. Hit him with the text
Judge,
messages.
may I approach?
There it is. Finally.
Sure.
This is what
Come
happens
It's
when
in one
you're
of the ones I gave
prepared.
you.
You have the text messages ready. You ask him a question. As soon as he says no, you stab him with the paperwork and now make him read it. You read the highlighted portion. That's the way you do this, people. Hopefully she's woken up. But yeah, you got to have that ready. Come on. And you have him read it. You don't read it. You read it. Make it come out of his mouth. It gives you a bit more effect.
Look at that and let me know if it refreshes your memory.
Damn right it refreshes his memory.
so when that,
So just first let me know if that refreshes your memory.
yes,
Okay.
yes.
So it's true that you told me that they took many trips to Florida, correct?
Per that, yes, but
That's it.
one of
We
the
don't wanna hear nothing
messages
else.
is cut off. And you asked about some other trips, and I said, no, I
I
didn't.
didn't ask you about
I
all
think.
that. I just asked you, did
And
you
that
say that
was
other thing? I didn't ask you
specific
about all this other
to,
stuff.
at the top of that, it says, no, I didn't. And
He's not controlling the
so
witness. You gotta shut him up. All this is irrelevant.
that was to the trips that you asked me about. And I think before that, when you mentioned that you found all these trips, I think I said, oh, wow. And
You did not know about all the trips that were taken, and you qualified it. You said, no, I didn't. When did it happen? And then the next text, which I can get, or you can look at your phone or whatever refreshes your memory. You said was after you left, after the firm was dissolved, correct?
Subject to relevance.
Overruled.
Yeah, the relevant.
It was after the firm.
He's just throwing out crazy
The trips
objections
that
now.
you said, no, you didn't know about. You told me those were after your firm had dissolved, correct?
I think you mentioned that they were after I left, maybe, or whenever you found them. And I said, no, I didn't know about those trips. So
So you believe I mentioned that it was after you left?
I'm quite sure you have the text message, and I will
Yeah,
refresh my memory.
Just
Is it
hit.
easier for you to refresh your memory with your own phone or with my printouts of screenshots?
Well, you have the printout, so I'll go.
Judge, the reason I'm asking is because I'm getting objections that I've cut things off, and it's just the nature of how you have to print out screenshots. So in order to avoid that, I'm happy for him to refresh his memory with his own phone, if that would be,
Well, I don't know if he's accepting your offer or not, so you're going
would
to
that be
proceed.
easier for you?
You can just provide the documents.
Okay.
Now you see, this is what I'm talking about. You have to have all this stuff prepared. You don't want to be sitting there looking through documents. I already know what I'm going to ask you. I already know what's going to be. So I expect you to lie. When did this happen? Okay, isn't this what you said? How did you learn this? Like this should be easy. But she's fumbling around with text messages and stuff because she doesn't already have it ready. You should automatically, like you remember Camille Vasquez?
Please.
Yeah, let me see what I can
Camille
do.
Vasquez with Amber Heard. You didn't see them looking around for stuff, right? She was like, "Did you say this?" Nope.
Sorry,
Let me
I'm
get
just trying
this.
to pull out all
Let me
of
get
the
this.
messages.
Let me
that
get
connect
this.
me.
All right. Well, I don't really see
Yeah, you're
at
taking too long.
some point we're reaching the cumulative point where we don't need to go through an entire 6-month text chain. You're making the point that he'd made some comments to you along the way that led you to believe he had more knowledge than today he's testifying that he had.
Now the
And
judge
so
is
if you've
telling
hit
you
the
it's
high
over.
points of that, then
The judge is telling you it's
I
over.
don't know
now.
what else we can cover that actually moves the needle.
You,
Okay.
you,
I'll
you're
just-
wasting my
I'll move
time
on,
looking for
to
this
the actual
craziness.
person.
You're
So you told me that they took
many.
many trips to Florida. That refreshed your memory. Told me that. Was that based on your knowledge from Mr. Wade?
I know Trump's attorney's like, tag me in. You
That would have been based on anything that my client would have told me. I didn't have personal knowledge of whether they went or not.
The trips to Texas, and you're the one who went to Texas. Was that based on your knowledge from Mr. Wade?
It would have been something that came from the client. I cannot tell you that I have any personal knowledge of any trip other than what would have been said by the client.
You went on these trips. I'm asking if you have knowledge from Mr. Wade. You also typed California. Was that something that you gained from knowledge from Mr. Wade?
It would have been from the client at this particular point. Yes, it would have been from the client.
And when you told me that the trip to California was to move her daughter out there, would that have been something you gained from Mr. Wade?
Thank you, Judge. Any knowledge that I have of any trip would have come from my client at the time.
I don't know. I don't know. I don't know why she's not doing it. This lawyer going to
You
want
told
ask
us
questions
last
to-
week that
but have
Mr.
the
Wade
answer
used your
prepared.
credit card one time. Do you know when that was?
I do not.
Relevance to why we're here today.
Well, I think this would be impeachment of Mr. Wade's testimony if Mr. Wade testified that he had never used anyone else's credit card
I
before.
object to ask him either because it was covered during the last hearing. And you acknowledged that Mr. Wade used his credit card.
Judge,
So
I asked when.
just
I didn't-
win. Okay,
Yeah.
I didn't ask, did he? I asked, when
I
did he?
like that.
let's go there.
I do not have any dates of when Mr. Wade used my credit card. I testified that we used the card for business and that throughout the business, we would order paper or supplies or filing of depositions. I mean, the cost factor of cases is what I said. And that still applies today. Did he use my credit card? He did.
Yeah, it does.
But I can't tell you who he used that card, what the trip was for. I can't even tell you at this time where he went.
But he used it for a trip.
Yeah, it was for a trip, but I can't tell you where, when, why, or anything to that nature. Correct.
You got him, man. Still reeling him
Paid you
in.
back in cash.
I never testified that he paid me back in cash. I said
She
that he
added
would
that.
either pay me back. I said I couldn't remember. I do not recall. Sometimes he would write checks. Sometimes he would pay cash. And that still applies today, that I do not recall him paying me back cash, but I do recall him paying me back.
This was when you were still, before your partnership split up, correct?
It would have been before I left the firm. Yes, he wouldn't have used my card after I left the firm.
So we can at least narrow down the dates to that.
Yes.
Before I left the firm, yes.
Okay, great. And Mr. Wade gave you details about meeting Miss Willis in Hateville or East Point, as it was called.
That's incorrect.
He did not tell you about that.
He didn't give me details.
But he did tell you. See, what's his line by
He
omission?
did not tell you about meeting with Miss Willis at an East Point or Hateville apartment?
That's true. No, he doesn't keep his lawyer title. He's going to be gone. He doesn't want to answer.
At this time, I don't recall.
He doesn't want to answer because it gives him a time frame that he knew about the
No,
relationship.
I don't recall.
Where did you get that information from then?
Oh yeah.
It's testified he doesn't recall if he even had that information.
I asked if he got it from Mr. Wade, and he says he doesn't recall. So then I asked where he got it from.
She's getting
I do
pissed
not
off.
recall where I got the information from.
To get pissed off.
And you and Mr. Wade were friends as well as business partners, correct?
We were friends in the sense of I've known him for years. Yes, we were friends.
And you definitely did not want to come and be a witness in this case, correct?
Hell no, he didn't.
That is correct.
And
Yeah, that
it was
coaching.
after, and we talked about this earlier, that Gabe Banks called you and then Nathan Wade called one of your friends.
They're coaching.
It was after that you hired Mr. Chopra to assist you in this matter, correct?
Was it after that? So
Baby, to let him
I
know.
heard Mr. Chopra and I heard Mr. Graham. Now, Mr. Graham is here, and when I received the subpoena, Mr. Graham was here at the last hearing, but he also had to go out of town, but he was present. Mr. Graham, I called, and I had started getting calls from media, and I told him to respond to the media, I think, and that was somewhere around whenever you subpoenaed me. So it was, I can't tell you that it was that instance of those calls for Mr. Chopra. But I had engaged Mr. Chopra and Mr. Graham at that time.
I'm going to ask the question again because I didn't get an answer to it. After you got the phone call from Gabe Banks and from Nathan Wade to your
I think it was before that, but however, I think it was before that is what I'm stating.
when you got from Gabe Banks, you called me immediately. Well, actually, you texted me and then you called me.
I didn't call you immediately, but yes, we did speak.
And you texted me about it as well.
That is correct.
And then we spoke after Mr. Wade called your friend, and we talked about that as well, correct?
That is correct.
And at that point, you didn't mention anything to me about being represented by Mr. Chopra.
But I didn't mention anything about Mr. Chopra or, that is correct.
Yes, that was only my question. Let's see. I'm gonna show you two more texts. They're in the ones.
All right, Ms. Merchant, we're going to do
Those are the
5 more
last
minutes.
two questions. Thank you.
3:05, I'm cutting you off.
Thank you.
The judge is like, this is enough. She's wasted all this time. This is what happens when you don't have everything tight. It gets boring, and the judge is like, I've heard this, I've done this. You can't make your points. If she had everything tight, it would be smooth. But now the judge is even tight. You got
May I approach?
five more minutes.
Show you a couple texts to refresh your memory, and then I want to ask you questions.
When he started testimony. Stress. He's under the stress. Thank you, Patricia. Thank you so much. So just so everybody understands, the judge knows the answers to most of these questions already because they did an in-camera review. But he needs to be asked them on the record so the judge can use the record to make the determination. But it seems like
Are
this
these
lawyer is not
supposed to go
getting
together?
to him.
No.
Oh, these are two separate dates?
Different days.
Okay, all right.
He needs a hug. Okay. Oh no, he needs a big time hug. But don't forget, he's done this himself. He did this all to himself because he's the one that went to her and gave her all this information. And that's what she's supposed to be. So when you said this, where did you understand that from? Pure perspective. When you said this, where'd you get this from? Like she's got to go through everything, but she's saying it in a way that's just too much.
Footnote. But do you recall me asking you, do you think it started before she hired him? And you said absolutely. Do you recall that?
I see that in the text message, yes.
Okay. And do you also recall me asking you how they would react if they would attack me?
When the relationship
And you
started.
said, no, they will deny it.
Your Honor, objection as to speculation as to how he thinks they will react.
I think it goes to the motivations of the witness.
Motivation
overall.
Even though it does.
And you told me that they will deny it.
That's written in there, yes.
I just want to, one last opportunity. You're an officer of the court, correct?
I am.
And you're under oath today.
I am.
Is there any of your testimony from today or the previous days that you want to correct?
That I want to correct?
Yes.
No, I've told you everything that I've answered everything that you asked.
Thank you. Oh, Judge, just so co-counsel and the state can have them, for the record, I can admit those few that I showed. That would be.
Well, they weren't ever tendered.
And
So it's just for,
I didn't know if they wanted
Right.
to use them, but I'll hold on to them.
if they need to be tendered at some point, then we can make them part of the record.
Well, I got
All
to give
right,
it credit.
let me turn over to Mr. Sadow.
All right, now
If you're with us on
Sadow.
Zoom.
All right,
Thank you, Honor. I do
Sadow's
have a few
good.
questions.
Here it is. Sadow.
First thing
Sadow's
I'd like to
good.
know is whether the court reporter has defense exhibits 26 and 27 from the last.
We
You
have
see,
a
Sadow has
different court
everything ready.
reporter this
Boom,
time.
boom, boom.
We had to have someone else fill in on such short notice, but I can potentially send those to you if you need them.
Well, I think I have working copies, but I want to make sure that the witness has a copy to look at.
You see, before he even asks his questions,
All right.
he
we
needs
can
this
try
stuff to
work
look
through
at
that
because we're about to
logistical
blow him
challenge.
up.
This is, you said 26 and 27?
I believe that's correct. And 26
Ah, come on with
I
the
think
likes, people.
is the same text messages that Miss Merchant was just asking about. It was
See?
2 pages. I stapled it together and it is dated January the 5th of this year.
All right. I can print off a copy now, but why don't we start off with the questions that you have?
He wants to be
Okay, 'cause
prepared. Like I'm
That's
gonna,
where I want.
I'm going.
That's
into
where I'm
that.
going to start,
He needs
but
to have
I'll
that.
see what I can do to work through it.
It's not going to work. Here, I'll lean on to you.
Yeah, yeah. Well, he deserves all this. Remember, he went to them. He went to them, and now he's trying to pretend that he doesn't. I was speculating on all this stuff, and he's full of shit. Here we go.
All right, Mr. Sadow, why don't we start with your question, and we'll see if we actually need to get a copy of those exhibits in front of the witness.
All right, here we go. Say
All
that.
right. Mr. Bradley,
Yes, I'm here.
all of a sudden I've lost you on the screen. There we go. Well, you're on the Zoom. You're on YouTube, but you're not on the Zoom itself.
Oh, he watching YouTube. Hey, what's up,
So I can
Steve?
see.
He's watching us.
I'm here. I can hear you.
No, I know. I think his visuals may be a little different. So hold tight, Mr. Sadow. We could try
He's
to
like, I'm
correct
watching
that.
YouTube.
Yeah, he was on, he was on when Miss Merchant was asking
Oh,
We
questions.
we
Be
need
able
to add
to
a.
see you and him.
I know. We need to add a spotlight to Mr.
Steven's got
to
that
the
booty
witness stand and
warmed
a
up. He's like,
spotlight to
give him the
Mr.
paperwork,
Sadow.
give
We
him
don't need all
this.
the other
We about to
boxes.
spank some booty.
There we go. Thank you very much.
Well, then hold tight, Mr. Sadow. We need to add you as well.
See, Nate, you taking Trump? What do you mean? I don't get this thing. Taking Trump.
All right. Now we're ready.
Where am I taking Trump?
Thank you, sir. Mr. Bradley,
Here we
you
go.
have referred to Mr. Wade as your client, correct?
Correct.
You understand that the court has ruled that communications that you had with Mr. Wade are not privileged, correct?
You see, he's breaking it down.
No, I'm
Yes or
aware
no?
that the court ruled that one specific dealing with the time frame of one specific conversation wasn't privileged.
Then I'm going to ask Your Honor, if it's at the limitation or
Excuse me. To clarify, I think, sure.
Sorry.
Mr. Sadow, you asked whether all communications with Mr. Wade, I think, were covered. That was not the extent of the ruling. The only ones that I deemed were not covered and that I'd asked about in the in-camera hearing, because those are the ones that were relevant, were any communications Mr. Wade made regarding the existence or non-existence of a romantic relationship with Ms. Willis.
Fine, thank you, Your Honor. I understand. So going back to this line of inquiry, when you say you don't have personal knowledge, what I want to ask you to start with is very simple. Did you have communications with Mr. Wade about the relationship between Mr. Wade and Ms. Willis? It's a simple yes and no.
Yes.
Good question.
And is it your testimony that during the time you were representing him, which I understood started sometime in 2018, is that correct?
That's the time frame that I remember, yes.
Okay.
Is it your testimony under oath that with regard to conversations with Mr. Wade about his relationship with Ms. Willis, that you only had one such conversation during the time you represented Mr. Wade?
One conversation of what? I apologize.
The only thing I'm asking about is that area that the court said is not privileged, which is the relationship between Mr. Wade and Ms. Willis. You've testified that during the time you represented Mr. Wade from 2018 on, that you only had one conversation with him in reference to the relationship between Ms. Willis and Mr. Wade. Is that correct?
Yeah, I think that's fairly accurate. Yes.
There it is.
Okay,
See?
so out of the entire time, I'm talking about could be 2018, 2019, 2020, 2021. When did you stop representing Mr. Wade?
It was a few months after I left the firm.
All right, give me the approximate time.
Oh, I know where he's going with this.
I left maybe June, July of 2022, maybe.
He's smart. I know where he's going with this.
So that would suggest that for, assuming it's 2018, 2019, 2020, 2021, and half of 2022, which is in the vicinity of 4 to 4.5 years, you're testifying under oath you had one conversation about a relationship between Mr. Wade and Ms. Willis. Is that correct?
It seems a little crazy, right?
I don't recall having any other conversation with Mr. Wade about him and Ms. Willis.
Only 1 in 5 years, and that was the person
Is it your
he was
testimony
cheating
then
on his wife
that you
with.
don't remember any other conversation, or there wasn't any other conversation besides the one?
An object is to ask and answer.
I think he's drilling down.
Yeah,
I
he's
think
drilling
it's a fair
down.
question
Yeah, it's a fair
overall.
question. Yeah,
I don't recall.
don't recall.
I
now.
would say it was the one, but I don't recall.
You testified that you did have communications with Mr. Wade about him visiting with Ms. Willis at a condo or apartment, correct?
He did
I don't
say
think I
that.
testified that I had a conversation. I testified that any knowledge that I would have known anything about any condo would have come from that, but I don't recall a conversation about that. I do not recall a conversation about that.
Do you recall any other thing at this point in time under oath that would indicate when the relationship started between Mr. Wade and Miss Willis?
I do not know when the relationship started between Mr. Wade and Miss Willis. I cannot
So I'm
recall
gonna-
that. I can't. Oh, I'm sorry. Go ahead.
I'm going to drill down on that now. Okay.
Now this is why you
Yes,
do
sir.
it. Ask the general note. Now you
Mr.
drill
Wade
down.
was hired as the special prosecutor on November 1st
Yeah,
of
he's
2021.
It's called boxing.
You're
him
aware
in.
of
He's gonna
that,
box
correct?
him in.
I have my contracts to show when I started.
He didn't ask
No
for
one
that.
showed me the contract of when he started, but but if he has a contract for November 1st of 2021,
That's what.
then
it is.
that's
Contract.
correct.
All right, that's where we're going. Good.
I'm going to suggest to you that the record will reflect that the contract between Miss Willis and Mr. Wade was November 1st of 2021, correct?
That's it.
I want you just to accept that, okay? Is it your testimony that you don't know under oath whether or not there was a relationship between Mr. Wade and Miss Willis before the contract?
That's the question. There it is. There it is. That's the question.
I do not recall any dates of when the relationship started.
That's the
So
question.
whether you are
I don't care about
pinpointing
the
a date
dates.
of when his contract started or not, I'm telling you, I did not recall any specific date that he
He said
flat out
specific date. He didn't ask about that.
said anything
Anytime before
about a
then.
relationship with Miss Willis.
Now I want to go, based on what you've just said, let's go to what was Defense Exhibit 26.
Now he's going to
Okay?
impeach him. Okay,
In Defense
so
Exhibit 26,
this is
which
what you
I
said
showed
before.
you last time, was 2 pages of text messages between you and Miss Merchant,
Here we
correct?
go.
Correct.
You said you don't know. Now
Now,
we're going to see
The
what did you mean
first
by these?
page starts off by saying, Miss Merchant, like just date, don't hire him. Do you think it started before she hired him? You see that?
Yeah, he sees it. He doesn't want to see it, but he sees it. This is. You see how Trump's lawyer? He's breaking them right down. Let's give him cornered right to.
Yes,
okay,
I see
now
it,
let's
yes.
break it down.
And your response to that was absolutely correct.
I'm gonna object, ask and answer.
Of course, he's going to object.
so,
of course,
Mr. Sadow, I do think we went through a lot of these texts.
but not and that as
We didn't
clearly
go
as
through this whole one.
Just a second, Mr. Sadow. All right. I'm sorry, Mr. Sadow. Well, you said we didn't go through this particular one?
No, we stopped right there. I want to go.
No, I answered.
Yeah, see, he
this-
does like I don't want
this
to
is the
answer.
exact
Don't
language
want to
that
answer
she
that
just
question.
stated
Yeah,
a few minutes ago.
I'll answer.
You can
this.
read it back
Okay, Mr.
in the
Sadow.
record.
Are you saying both of these two exhibits weren't already covered by Ms. Merchant?
It was not gone, this particular language was not gone into. I'm doing it based on the exhibit itself. Well, let's do it this way. I now moved into evidence defense exhibit number 26.
Fuck it, I'll put it in evidence and we'll
All
do
right,
it that
and
way.
I have to search through my notes, but does anyone recall that one actually been tendered in a minute already?
No, it was only presented to your honor for you to take back into camera ex parte to speak with Mr. Bradley and his counsel.
You see, he's ready.
Okay.
He's ready.
Ms. Merchant is indicating that it was admitted.
I thought Mr. Sadow admitted it, but I'm organizing, putting them back in order.
She's still
so
confused. I don't really know. I
might be
think it
easier if I
was,
just
and it wasn't.
admit the copies of the
All right.
documents we're all referring to.
All right, so defense exhibit 26 and 27 are being tendered.
Here we go.
Actually, only 26 at this time.
Oh, excuse me. Okay, defense exhibit 6, any objection from the state?
26.
26.
I'm going to object as it relates to foundation and authentication. It was used to, during the last hearing for the purposes of refreshing his recollection. And it's my recollection is that it didn't refresh his recollection, but I would renew my objection as to asked and answered in cumulative.
They don't.
Okay.
They don't want.
As to foundation on authentication, I think Mr. Bradley has recognized them as texts that he sent and received. So I think I'd overrule on that basis. Any other objections to their admissibility from any other defense counsel? And seeing none, defense exhibit 26 is now admitted. Mr. Sadow.
Thank you. All right, let's continue. Now I'm publishing it. After you said the word absolutely, on your own, you said it started when she left the DA's office and was judge in South Fulton. They met at.
Check.
Yeah.
Asked and answered.
All right, understood, Mr. Body. I'm going to let Mr. Sadow have a few minutes on this.
Yeah.
And
Hey, John,
we'll go from there.
Don't answer, but you see,
Judge,
see the difference.
Well, I'm sorry. I did answer this. I answered it for Miss.
See, I got to stop it right here because, as you can see, the way he's asking the questions is so pointed. You got to. But she asked the same questions already, but you don't even remember it, right? Because he's asking him in such a specific way to force you to answer it. That's why this guy gets paid the big money.
Understood.
Merchant, I stated that I was speculating. The judge, someone objected to the speculation, but this was
now he
the
remembers
exact same
everything.
language.
Mr. I can't
when I
recall.
said that I,
He remembers
Mr. Sadow was asking the question in a slightly different manner, and I'm going to give him a little bit of leeway.
See,
So,
Bradley's
Mr. Sadow.
you don't want to answer it. You don't want to answer it.
All right, I hesitate to have to start back where I was, but after the word absolutely, you on your own said it started when she left the DA's office and was judge in South Fulton. They met at the municipal court CLE conference. That's what you said, correct?
that is correct.
Now, it's your testimony, at least so far, that when you on your own gave those two statements in the text, that you were merely speculating and did not have that knowledge from Mr. Wade. Is that your testimony under oath?
Yes, that's what I testified to. Yes, sir.
So you on your own came up with the whole notion that it started when she left the DA's office and was judge in South Fulton. That's, according to you, that's speculation on your part, correct?
Objection. Asked and
Overruled.
answered.
Overruled,
Answer the
yeah,
question, Mr.
overruled.
Bradley.
You got to
Yes,
answer that one.
that's speculation on my part. Yes.
Right. It had nothing to do with what Mr. Wade had told you, correct?
I answered your question. I was speculating to the answer. That is correct.
So maybe you can tell the court in your own words, why in the heck would you speculate in this text message and say that it started when she left the DA's office and was a judge in South Fulton? Why would you speculate and say that in a text?
There it is. Boom.
I knew
Answer
they
that.
had met at the municipal court conference.
How do you know that? I'll stop you right there. How did you know that?
How'd you know
I
that?
answered that the last
No. He asked you
uh,
now. How did you know
I'm
that?
asking
I knew
you
that.
now.
See?
I knew
No,
that
I'm
because
asking
You
when
said what I'm saying.
I'm asking you questions and you are in a situation where you get to give answers. I'm asking you, how did you know that?
Yeah. How? I'm asking the same question.
how did I know
Somebody
when they
told-
met?
Somebody told you that, right?
When they met?
Yeah.
Yes, correct.
Who told you?
Mr. Wade told me when they met.
But you said just
So you
said
had
have
more than one conversation
conversation.
about the relationship
Boom!
between Mr. Wade and Miss Willis because he told you where he met her.
Busted.
That's incorrect. Incorrect.
Busted.
It's incorrect.
It's incorrect.
You
Let's go back
lying.
to the exhibit.
Busted. Yeah,
Why
gotta-
would you
Let's go back to the
speculate
exhibit.
that that's when they started the relationship? What would cause you to put that down as speculation?
Why are you
I
speculating?
don't recall, but why I thought that it started at that time. But I do recall that he only met her, and I testified to that he met her at that conference, which was in 2019.
You knew that Ashley Merchant represented a defendant in this case when you were text messaging with her, correct?
Yes, he did.
Yes, I did. Yes.
And you knew that the reason she was asking you questions about Mr. Wade was because she was trying to show when the relationship began, correct?
Yes. You see?
No, that's not
You can
It's
find
not
it.
what's the
100%
beginning of the
correct.
text message.
Get the text messages, people. Let's go back to the text messages. Still waiting for the reply.
Yes, but
Text
what messages
Thank you.
were before this message, before she
Let's
sent
write a
that?
note for that.
I
Thank you.
can't answer that question
I
because
got
I
that
don't
email
have
too.
them. All I have is what's in front of you. And it
Yes.
says that she says, do you think it started before she hired him? So you knew, as the counsel for a defendant in this case, that Miss Merchant was asking you specifically about the knowledge that you had regarding the timing of the relationship between Wade and Miss Willis, correct?
I mean, based on this, yes, I see
And
what was asked.
And in response to that,
Going
you
through the shadow
answered directly on your own what you now claim to be speculation, right?
realm.
That's correct.
So I ask you one more time before I move to the next part of this.
The next part.
Why would you speculate when she was asking you a direct question about when the relationship started?
I have no answer for that.
Except for the fact that you do in fact know when it started and you don't want to testify to that in court. That's
Steve,
the best
Shadow
explanation.
just set it out,
Overruled.
right? We all know what's going on.
That's the true
That's the
explanation.
truth.
Because you don't want to admit it in court.
You
correct?
can't handle the truth.
No, I have no direct knowledge of when the relationship started.
I'm not going to go back through that again. But if you didn't know, and you were asked specifically as this exhibit shows,
Don't want to admit it.
maybe you can explain why you wouldn't say, I don't know.
Speculate. We speculate. Your voice sucked now.
Is that a question? You're
Oh,
asking me
yeah.
a question to answer?
Definite question.
State that again. I apologize.
You don't
If
want to
you're
answer
being
nothing.
asked, as we've just gone through with this text message from Miss Merchant, as
Yes.
the attorney for a co-defendant,
Yes.
and she's asking you about the relationship, and she's clearly asking you about the timing, why wouldn't you just have said in response, I don't know when it started?
I don't know why I didn't say I don't know.
Maybe, again, it's because you know what the truth is, and that's why you answered exactly the way you did in Defense Exhibit 26, correct?
No, I can't sit here and tell you that what you just stated was correct.
Right. What you want the court to believe, and you want the rest of us to believe, is that for some unknown reason, upon being asked a direct question about when the relationship started, you decided on your own to simply speculate and put it down in a text message, as opposed to putting down what you actually knew. That's what you want the court to believe, correct?
That was a lot. So can you break that down? I apologize. You're asking me, do I want the court to
To believe that instead of saying nothing, you decided on your own to speculate.
Yes, I speculated. Yes, I've
Right,
stated that I speculated. Yes, sir.
Right. That's what you want the court to believe, correct?
That's correct.
Okay, now, then when you go to the next page of that, okay, you see it starts, the best that I can see, it starts in South Fulton. Is that what you have in front of you? Second page.
The second page that I have says, that's what I figured.
Okay, that may be cut off from the one that I have. I'm looking at my opening set line says in South Fulton. Is that on your second page?
No, so if you're going in order of the pages, no, neither page starts with South Fulton.
No, don't get caught up in whether it starts that way. Does the second page have a line in there that says in South Fulton?
Maybe.
Oh, yes, I apologize. So, yes.
That's fine.
Yes,
Just want to make sure that we're on the same page.
yes.
Okay. You say after in South Fulton, they met at the municipal court CLE conference, right? You
Yes,
see that?
is good. Yes, that's correct.
And then Miss Merchant says, that's what I figured when he was married. Is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. You see, that's what she said, right?
No, I mean, so
Yeah, he
it
sees it.
says
Wait,
that at municipal court CLE. The only other thing here says, that's what I figured when he was married. There's no response for me on that day. And then there's another response. I guess a question that says, is this accurate?
Okay, that's what I just went over with you.
Okay, so I don't have anything in that. Is this accurate at all? I can show the
No.
court. It's just,
Okay.
it just says, is this accurate with the question mark? I don't have anything following that.
You don't have, after that, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship.
Yeah,
with
okay,
that-
I apologize.
that.
It goes to the next page. I apologize.
He said,
No
go to
problem.
page
Just wanna
2.
Make sure that
But no, I see that now, yes.
All right, so that's what I just read is
Mhm.
exactly what Miss Merchant said to you in the text, right?
Yes, that was in the text. Is it accurate upon further information? Yes, that's there,
And-
yes.
Again, since you have told us that you were speculating when you gave the answer that we went over with previously, on this one, you don't say, I don't know. You simply correct her by saying no, municipal court, right?
Yes, so she asked, was it accurate? And I said it wasn't accurate. No, it wasn't accurate. It was municipal court.
Right. And when you said it wasn't accurate, it was municipal court, didn't say, no, that's not accurate. They didn't start a romantic relationship at that time, correct?
No, but I was referring to the municipal court. No, it wasn't accurate as it applied to I was answering the no municipal court, meaning when she said, is that accurate? It was to the municipal court and not magistrate court.
Okay. But you didn't say that the rest of what she asked you was accurate. You didn't say, no, that's inaccurate. That's not true. That's not accurate. You simply said the only thing that wasn't accurate was municipal court should be there instead of magistrate, right?
That's what he said.
So I was answering the question of, it was a compound question.
Can you
And I was answering the question of,
His head is shiny, boy. You know, he's sweating it up.
she wrote magistrate court and I said, no, municipal court.
Right, but it's not compound. It's one statement upon
Mr. Sadow.
information and belief. I'm sorry.
No, that's okay. I know the feedback and the delay is complicates things, but I think you've adequately made your point here. I don't think we need to belabor it much longer. Let's move on to the next issue.
Okay, thank you, Your Honor. Mr. Bradley, prior to coming into court today, did you and your lawyer meet with anyone from the district attorney's office?
Smart question.
No. I mean, no, not that I know, I'm aware of, no.
He said, I'm
Have you
I
had
did not
any?
meet to anyone.
I'm sorry.
I did not meet with anyone outside of my attorneys.
Did you have any conversation? Not
I did
meeting,
not.
conversation.
I did not.
So you have not spoken, if I understand you correctly, prior to coming into court today, you've not spoken with the prosecutors,
No,
right?
I've not spoken to the prosecutors. I've not spoken to defense.
Have you spoken to Mr. Wade?
No,
So as far as just getting into the courtroom today, there's been no contact or conversation in it with any of the parties we just went over, right?
there has not been any contact with defense or the state at all.
I think I have basically just one or two more questions. Why would you see the need to speculate when you were texting with Miss Merchant?
I think we did cover that
Yeah, we
one,
covered that one.
Mr.
Yeah,
Sadow.
he's not gonna let you get through that one.
I think that exact question was already put to him.
He's already won. You've already won on that point. Move on. You've won
What
that.
would be the next one?
Yeah. You've won that one.
I'm trying to look. Let's go to 27.
So then they're going to go to text message 27. So he's essentially won on that
27.
point.
Do you have that now, sir?
I do, sir.
All right. Would you look at it and tell me whether or not the Defense Exhibit 27 appears to be accurate? Because I want to seek to introduce it into evidence. It consists of an email to you from Miss Merchant and a text response from you, correct?
But the text response was not in response.
He's not asked the question. He's just.
So yes, it does consist
It's
of
asking what it's
the
consistent.
email and a text response. I'm not
No,
saying
I
that
can't
the text
recall.
response applies to the entire email that was sent.
All I've asked you right now is
Yes,
the email and the text, are those accurate in the interaction that makes up Defense Exhibit 27?
as it applies to the stapling of the email and the stapling of a text message chain, yes, that is Defendant's Exhibit 27. This is, it's accurate.
Okay, I would move Defense Exhibit 27 in. I believe it was treated the same way as 26 last time, Your Honor.
Same objections, Mr. Abadi?
Yes, Judge.
All right, overruled. Any other objections from defense counsel? Seeing none, Defense Exhibit 27 is admitted.
And, Your
Anything
Honor, I
else,
don't
Mr.
know.
Sadow?
Yeah, I don't know whether you'll find this objectionable or not. I'll ask it, and obviously.
All right.
Mr. Bradley, you realize that if you were to testify under oath, that you knew from Mr. Wade that the relationship between him and Miss Willis existed before the contract in November 1st of 2021, that if you testified that you knew that from Mr. Wade, that would show that both Miss Willis and Mr. Wade had lied under oath. You know that, don't you?
Yeah,
I'm gonna object.
I think that's going to call for an opinion on the credibility of another testifying witness. I don't think that would be an appropriate question.
But just put it out there.
And that's all I have, Your Honor.
Thank you, Mr.
there,
Sadow.
right?
Mr. Stockton,
Just briefly, Judge.
we'll see.
Everybody said just briefly. It's never
Mr. Bradley, do I understand from your prior testimony that Ms. Merchant sent you a motion to review prior to her filing it?
Objection.
Yeah,
I'll some cumulative answers.
All right, I'm going to give him just a little bit. All right, Mr. Stockton, maybe this is going somewhere else.
Did Mrs. Merchant send you a motion prior to January 8th of 2024 for you to review?
That is correct.
And did you in fact review that motion?
That is correct.
And did you indicate to Ms. Merchant that the contents of that motion seemed okay to you?
Well, so you're referring to Exhibit 27, which, as I stated a few minutes ago, one is an email, one is a text chain. So in the text chain, when I never responded to the email, I never responded looks good or anything to the email that was sent to me. However, in the text chain, what you all are trying to merge together is the fact that I was asked about the contract, and that contract was $74,000, and me being added back to that. So when I said, and I think before that in that text, it referred to me being added back, and at that time I said yes, looks good.
And
What?
you're aware and you recall that
Desperate.
when Ms. Merchant presented you with that motion, she asked you not to disclose it to anyone until she filed it. Is that correct?
We are covering, I think, the last 5 or 6 questions. We've covered ground. Let's get to that ultimate point.
I'm trying to get there, Judge, I promise you.
Okay.
Judge is like, yeah, I'm gonna go home.
Repeat the question, I'm sorry.
She asked you not to disclose that motion to anybody until she filed it, correct?
I think so. I think that was in the text message, yes.
And you knew, in fact, it was her intention to file that motion, correct?
You know.
The actual motion that she
It's reviewed, yeah.
that was sent.
Yes.
I knew that she was going to file a motion, yes. I do not think that that was the final draft, or it could have been that she was working on it, but yes, I knew that she was going to file some motion, yes.
And you knew that she presented that motion to you for your review so that she could make sure it was accurate, correct?
Your Honor, I'm going to object. All this is asked and answered and cumulative.
All right,
That's
noted.
okay, yeah.
I think Mr. Stockton's getting to the next point.
Let's
So
get
why
to-
don't we just ask that one?
He's got to get to his point. We got.
Is that correct?
Did you
Uh,
know that?
we
I
can-
thought
why don't we
you,
combine that with the next question, so we're not having to lay bit by bit every single time.
Mr. Bradley, you knew that Mrs. Merchant was relying on your review to ensure the accuracy of that motion prior to filing it, correct?
Speculation as to what he knew that Miss Merchant knew.
No,
But I
I'd
do.
overrule that. Mr. Bradley?
no, so once again, I was excluded from the footnote of that motion. And my review of it, and I said, hey, you need to add me back to the footnote because I did have a contract and I did receive 74,000.
So he read everything, even the footnotes, and now it's complete. So yeah, like you read everything literally. Even
If I
and
may
said
help you
the
out,
footnotes are wrong. That's
Let's
how
talk
detailed you
just
read it.
about that part of the motion that deals with the relationship between the District Attorney Willis
Mhm.
and Mr. Wade.
Mhm.
When you reviewed that, you knew that that Ms.
No.
Merchant,
No, I did not know that she was relying on me for any relying on me for any accuracy other than what was put in there
if there
about the
was,
74,000.
Mr. Bradley, if there was something patently false in that motion, you would have told Ms. Merchant, wouldn't you?
I can't say that I would or wouldn't have. I don't know what I would have told Ms. Merchant.
If there was something patently speculative, you would have told Ms. Merchant, wouldn't you?
I don't know what I would have told Ms. Merchant. She asked me, was it accurate?
And you told her what wasn't accurate. Like I understand where they're going with this.
We were discussing the 74,000 that was left out.
Again, if I may direct you just to that portion dealing with the relationship between Mrs. Willis and Mr. Wade. You didn't tell her that there was anything patently false in that because you didn't see anything patently false in that motion as it relates to the relationship.
Repeat your question. I'm so sorry.
You did not inform Mrs. Merchant that there was anything patently false in that motion that you were presented with as it concerns the relationship because you did not see anything that was patently false, correct?
Objection asked and answered cumulative.
All right, next question, Mr. Stockton. Sustained.
And you didn't see anything that was speculative in there
All right.
either, did you?
And answered
I
cumulative.
know, sustained, Mr. Stockton.
Yeah.
I just want to ask you one more question. I'm coming at it from the other way that Mr. Sadow did. Did anybody from the district attorney's office or any witnesses in this case contact you about Ms. Merchant's motion from January the 8th of 2004 until today?
No one's contacted me.
Did anyone contact me about her motion?
Yes, from the district attorney's office or any witnesses or anybody else involved with the case besides the defense?
Other than the call that the only personal call that I had was with Gabe Banks. I never spoke to anyone else, and to my knowledge, he's not a part of this. So
That's all I got, Judge.
Thank you, Mr. Stockton. Mr. Durham, if you're still with us.
No question, John.
Thank you, sir. Mr. McDougal.
So here's somebody else. They're trying to get to the one. It's obvious he knew there was a relationship
afternoon,
before
Mr.
that
Bradley.
time, but now they're just trying to get him to say it in a way that's
You have
clear.
certain information about the relationship between Mr. Wade and Ms. Willis that is not privileged, correct?
Well, that was my determination, so I think he disagrees with it. So what we're going to say his opinion's a little irrelevant on that point.
Do you understand that the court has ruled that certain information that you have about the relationship between Ms. Willis and Mr. Wade is not privileged?
I'll tell you right in
I
the
have-
break.
the court's ruling, as I understood it, and as my lawyers and I understood it, of the privilege not existing was based off of a conversation that was had in my office, in the back of my office, which was confidential, with Mr. Wade and I. That's what was asked of me on yesterday, and that's what the ruling, to my knowledge,
So what was that?
unless I'm being
conversation?
corrected here now and saying that it's more, it was that particular piece that the judge said did not have privilege.
And have you testified already today to the sum total of your knowledge of the relationship that is outside the scope of the privilege according to the court's ruling?
Can you ask that again? I'm sorry, I didn't understand it.
Referring to what you understand to be the information that is not privileged, have you testified to the sum total of that information?
I think I have, yes, I think I've
That's
testified
excuse me, question.
to that, yes.
All right, sir. That's my questions.
Thank you, Mr. McDougal. Mr. Rice.
I would have just asked them. You got to ask him about that conversation. The conversation
Mr.
that's
Bradley, at least as of February 15th, when you first testified, you said that you still considered yourself a friend with Mr. Wade, correct?
I think I said that, yes, I think I did, yes.
And you've been friends with Mr. Wade for over 10 years, correct?
That would have been fairly accurate, yes.
And you recall communicating with Ms. Merchant about this case and about Mr. Wade and Ms. Willis's relationship, correct?
Going to object as to past and entered and cumulative by all three of the previous.
Sure. We don't have to lay that foundation. Why don't we combine it with the next question where you've got a new point to make?
Mr. Bradley, when you communicated with Ms. Merchant, did you tell her any lies about Mr. Wade and Ms. Willis's relationship?
People, sorry. We had a power outage right here, so everything went off. I had to let everything come back on. So let's get back to it. Sorry about the unforeseen issues. Hold on one second. Let me add this back up.
Yeah, she was gathering information, yes.
I'm gonna
Well, let's
start
look
where we-
at the
where we let
title
off.
of the motion that she
Again,
sent you.
sorry.
You
Literally
remember
lost
that
power
was
all
sent
throughout
on
the
the
house.
6th.
Excuse me, do you
Just got it
remember
back.
reading the defendant Michael Roman's motion to dismiss grand jury indictment as fatally defective and motion to disqualify the district attorney,
It
her office,
happens. It happens.
and the
I
special
can't control
prosecutor
the
from
damn.
further prosecuting this
We
matter?
have a
Do you
little
remember
storm
seeing
outside, so I
that
think it
in the draft
fucked up my
that
power.
you read and reviewed?
Yes.
So when you tell this court that you didn't know what she was up or what she was going to do, she kind of gave you a hint, didn't she, in the title of the motion that she sent for you to read? Didn't she? Yes or no?
I read the title of what the motion was.
There wasn't anything in the title that threw you off. Pretty straightforward speaking title, isn't it?
Correct.
So you knew that what she wanted was information from you so that she could then file a motion to dismiss the grand jury indictment, to motion to disqualify the district attorney and her office and the special prosecutor from further prosecuting the matter, right?
I'm gonna object to speculation.
You knew that, didn't you?
Overruled.
Yes or no?
When she sent that motion, yes.
Okay. And you knew that the special prosecutor that to whom she was referring in that motion was Mr. Wade, correct? You knew that
Yes.
because you read the motion. You said you reviewed it, correct?
Yes.
And we're not going to go over all of the, number one, because we don't have time, and number two, the court wouldn't let me. But but there are a few things that I do want to ask you about in that response, in that aspect. Now, in that motion that you said you
We
reviewed,
do have a lot of power outages.
on page 6 of that motion, well, on page 5, it starts off with, how do we know this? And there's a question mark.
All right.
Hearsay.
Yeah, Mr.
It's
Gillen,
not looking good.
I can appreciate what you're doing. I think that's something you can do at argument. He's said as a whole that he got the motion and he's had his response as to his opinion of how he handled it. I don't see that, again, this
They're saying why don't they
really
just ask
being
him
necessary to
what
go through it line
happened
by
in
line
his
of what.
Well,
motion?
a little indulgence, Your Honor. I'm not going to go, this isn't going to be a 40-minute death march through the motion. I would like to ask about a few bullet points that capture under this, and then I'll move on. But I would ask the court's indulgence in that respect.
Again, I think we've covered it, and I think that you'll be able to argue that this was in that motion and that he had a chance to review it, and he never objected to anything in there or raised it. So
That's the problem, and always ending up last asking
it very much is. And next time, I'll reshuffle the order.
Well, we did earlier with Mr. Wade, and then
I hear you.
that was kind enough, and then
Enough,
the
enough,
court
enough.
said we had to go.
You only need to
Judge
draw
is trying to get
straws
the hell
next
out
There
of
we
here.
go. I'll go with that.
All right. Anything
Thank you, Your
else?
Honor. That's all I
Okay.
have.
Okay. We had Mr. Kucherov potentially still on Zoom.
Yes, Your Honor, and I have just a few questions.
All right.
here we
Could
go.
we add a spotlight to Mr. Kucherov? I'll let you know when we're able to proceed.
So right now, I don't know this.
Judge, before he starts, can I take a 5-minute restroom? It's been
Absolutely.
2 hours.
Yeah, we've been going 2 hours. So let's come back at 4 o'clock. I'll also note for the record that we received a notification from Mr. Cromwell on behalf of Miss Latham, and he said he was waiving her presence. And I don't know if he later decided to join us by Zoom, but I don't think he was electing to log in. So after Mr. Kucherov, just in terms of timing, Mr. Abadi, do you have any expectation of how long your, if any, questioning would last?
I don't imagine my question will be very long.
Okay, well, let's get back in at 4 o'clock. Mr.
All
Bradley, you
right.
can just step out. Jerry.
Now that I've lost half the stream because the power outage here in the good old state of Texas. But what do we have going on? All right. With this while they were on a piss break. Yeah, I can mute this. All right, so let me just break this down what's going on. All right, so the person who you saw on the screen, His name was Terrence Bradley. He's the guy in the witness chair. He was Nathan Wade's attorney, divorce attorney. Now, the judge last week, I think on Monday, brought him in and said, okay, tell me what Mr. Wade told you, the privileged information or the theoretically privileged information. He told the judge something. The judge says, well, guess what? That's not privileged. You can be questioned on those particular incidents. So now he came back and now he's being questioned on it. But no one's asked him about the specific thing the judge said was not privileged, which was a conversation he and Wade had in an office, in the backroom office, about the relationship. Nobody's asked him about that yet, even though he said it multiple times. The judge said this one thing is privileged. Somebody said, okay, so what was the contents of that conversation? But he hasn't said that. So now, where are we at? So now he has been trying to avoid answering the one single question. And that question was, when did the relationship start between Wade and Willis? The reason why that's important, because we already have one witness who says the relationship started before 2022, before when Wade and Willis say, essentially saying they committed perjury. But by having this second witness corroborate the first witness, who happens to be Fani Willis's former best friend, if he corroborates it and says, yes, I know the relationship started before 2022, then that means one of two things. Both Wade and Willis committed perjury. And the committing perjury would be an easy way to get them bounced off the case. Why? Think about the motives here. What would the motive for them to be the lie, right? The motive for them to be the lie was to keep their relationship secret so they could continue on with this case. So the judge would be able to use that and say, well, because you're lying to try to keep this case and it's about disqualification, we're going to disqualify you because of the appearance. So that's the big fee here. That's why you see the attorneys fighting so vigorously for him not to say certain things or to answer certain questions. The $1 million question, the $1 million question that we are still waiting to be answered definitively is, did he know before Wade was hired in November 2021, did this witness know that they were in a relationship, physical, sexual, personal, that type of relationship? If that answer to that question is yes, game over. If it's no, it's not. Now, two things I think is important to know. Number one, the reason why a lot of you are trying to say, why can't he just answer it? There's a couple of different reasons. And I saw a couple of your super chats, so I'm going to answer that question now. Number one, if he's committing perjury or any type of these ethical crimes or anything like that, right? Who's going to prosecute him if he's committed a crime? It's going to be this DA's office. So he knows that he's got a lot of dirt, from the sexual assault allegations to all this other stuff he's got, that he doesn't want the DA's office to be looking into. So guess what? He happens to be now up against the DA's office. So I'm assuming that's in the back of his mind. Oh my God. But he has a lot of other stuff that he has to worry about that I think is even more damaging. One of the other things he's got to worry about is his own professional reputation and credibility, right? He's just essentially admitted to selling out his client for nothing, right? To a merchant, essentially telling her everything that was privileged. That's a problem, because who's going to hire a lawyer who gives up all your client's secrets, right? He knows. And then he has to be careful in the way he even answers these questions. Remember, before, he was the one saying that, well, particularly, he filed a lot of the documents that Wade filed under penalty of perjury. So he signed a lot of those documents, the interrogatories and things of that nature that Wade filed in his divorce under perjury. So now, since he is a lawyer that filed it, he essentially gave the court things that he knew wasn't true. If he knew that Willis and Wade had a relationship prior to him being hired, and he filed that with the court, then he himself would have supported perjury. He would have filled out the paperwork and submitted to the court knowing that it's false. So there's a lot riding on it for him professionally, because he can't now admit that he perjured himself during the court documents by saying he knew about the relationship. So that hurts him. But now if he doesn't say he knew about the relationship, it doesn't make any sense, because you were his defense counsel in a divorce. And obviously he had to tell you that he was having an extramarital relationship, because it makes sense to be part of the divorce. So Terrence Bradley's kind of screwed either way. He's screwed if he says, yes, I knew this information, because he loses his license and all that. And he's just giving it all to Ashley Merchant. And he's screwed if he said he didn't know it, because then it's like, it's essentially unbelievable that in this, he just didn't know. And from what I'm understanding, he had to know. He had to know. It wouldn't make sense. And he's essentially admitted he knew. Now, what they've been trying to do is essentially, they've been trying to ask him directly, but he won't give it up. He won't say, yes, this happened. Yes, this happened. So what they've been trying to do is work around it. It's try to essentially get him to say it without asking him directly. Well, when you wrote this in this email, when you wrote this in this text message, when you wrote this and this is, you obviously know. Now, it's obvious. If he's telling her he went to Africa, he went to this, he went to, they went all these places. He had some knowledge of it. But now he's saying he was just speculating, right? I was speculating. Well, why would you, all of a sudden, she didn't even ask you to speculate, but you're speculating. You're speculating that they had a relationship. You're speculating that with all these places. You looked at the thing and said it was all right, but you really didn't mean it's all right. And essentially, that's what he's trying to say. He's trying to just make it up. The reason why he could not answer that question, or he has no knowledge of it. Because again, his whole career is hanging in a balance here. Now, a couple of things I want you guys to realize too is that this clown did it to himself. This clown went to the other side and gave up all this information. He gave it to them. So he put himself in this hot seat. If he doesn't talk to Merchant, he doesn't say anything, then he doesn't have anything to worry about. But the fact that he did now goes to the whole thing, because again, generally, if let's say if he didn't go to Merchant, then they couldn't ask him anything. They wouldn't be able to drag him into court. He's like, yeah, I was an attorney on this. It's all of this privilege done. But since he did give the information to Merchant, that opened the door for them to inquire. Well, is this attorney-client privilege, or is this not a attorney-client privilege? And this is what blew it up for him. So I know a lot of people in the comments saying they feel bad for him, but I don't feel bad for him because he did this to himself. And no matter how much you like Wade or dislike Wade or whatever, think about what this attorney did. He literally gave up all his clients' confidences, gave up all of his privilege, gave it to this woman for whatever reason, to especially since that he knew that it was his adversary in court, and now, because of all that information, he's getting his client in this mess with the disqualification. And again, that's his friend and his lawyer. He says the guy's still his friend. So I don't know what type of friendship that's supposed to be about. But at the end of the day, he is he's a scumbag. He's a scumbag lawyer. And his license should be pulled and revoked because the information he's given out is privileged information. Oh, let's see what left-wing media touch is saying, because now I'm going to say it. When I play this, they're going to be all pro Fani Willis. This is nothing. It's big nothing burger Fani Willis. But if we let's think about the end result here. Think about the end result here. But let's not, even though the process is messy, think about the end result. Can we now, based on his testimony and this other testimony, can we trust Willis and Wade's assertions that based on their good name and their good character, that Fani Willis paid Nathan Wade back for all of that time, all of that money? And if you can agree, if you believe that's true, then Fani Willis goes, right? Fani Willis is good. But that's what we're all dealing with based on his good word. So the judge is back. Let's see what's going on.
Someone else is here as well. You may proceed.
Mr. Bradley, did you use any documents to prepare for your testimony today?
No, I did not.
When was the last time you spoke with Gabe Banks?
The day that I don't have the date, but it was the date of whenever the phone call happened.
And you know his wife, Kyra Banks, works for the DA's office, right?
Yes, correct.
When was the last time you spoke to Mr. Wade?
I haven't spoken to Mr. Wade personally in 2 years, actually, when I left the firm.
Miss Willis?
I never, my interaction with Miss Willis was never, where I would pick up the phone and talk to her, or that she would, or anything like that.
So you didn't hang out with Miss Willis? You didn't have a personal relationship with her?
No, I never had a personal relationship. I mentioned before that I went to a dinner that was after she was elected. That was at a steakhouse, but it was some 75 to 100 people there.
So you knew of her, you just didn't have a business relationship or a personal relationship with her, or at least a close one.
I knew of her from she was in the DA's office and I had criminal cases, but I did not personally know her, no.
And not having known her, not really hanging out with her, you've got a contract from her office.
I'm gonna just object as to cumulative asked and answered throughout the
All
multiple.
right, Mr. Chairman, I think we covered this ground on the 16th about the contracts. Do you have are you going somewhere else with this?
I am, Judge. If you give me a little latitude, I'll try.
All right.
To
Okay,
see,
you may
it's like
proceed.
they're asking the same questions
You
over
got a
again.
contract from the office, not knowing.
Lawyers are
or
used
having
to
a
laying
good relation-
foundations for what
good
they're trying to
working
get to. So
business
that's why
relationship with Miss Willis.
everybody's doing
That's
the
correct.
same thing.
That's because Nathan Wade steered that contract to you.
I don't know how it came about, but it was presented to me at the office about the contract, correct?
Who presented it to you, Mr. Wade?
Yes,
Is that, and he owed you money, you said at one point.
say that again?
I think you said he owed you money at one point.
I don't recall saying that he owes me money.
Did he owe you money at one point?
You've admitted to that.
Not that I recall saying that
Remember
Mr.
the
Wade
card?
owes
He
me
used
or
a
owed me
card?
money. I
Yeah.
don't recall ever saying that.
With the card, the credit
I
card.
didn't ask whether you ever said that. I said, did he owe you or did he owe you money in the past?
No, he didn't owe me money.
And so he steered this contract to you, to your office, and you weren't really talking to him? You hadn't talked to him for 2 years?
The contract was in 2021. I didn't leave until 2022.
So you didn't talk with him that whole time?
I left in 2022. I haven't really spoke to him since 2022 is what I stated. When I left June of 2022, around June, August
Thank you, Cheryl.
dates of 2022.
Scarlett, thank you.
Other than one last question, other than your attorney, who did you speak with today about giving testimony
Asked and
in
answered.
this case today?
I spoke to my attorneys, Charles Graham and BC Chopra.
I have nothing further, Your Honor.
All right. And again, I'll just double check to make sure. Did Mr. Cromwell ever join us by Zoom?
Now, look, I think that now, is the DA's office going to
Do we-
destroy this man? Because I think they're going to destroy him. I think they're going to destroy him. Can they bring testimony from divorce and try to establish a timeline? Yes.
All right,
they
thank you.
could.
So just for the record, Mr. Cromwell has been apparently watching the proceeding. He had waived his client's presence and didn't have any other questions as well. So turning it over to Mr. Abadi.
He's watching it on
And I
YouTube.
have no questions.
All right. Mr. Bradley, you can step down. Thank you, sir.
That's it.
Judge, you want these exhibits?
No,
The DA's
thank
office
you.
didn't say anything. All right. So I think they're just going to make a written opinion. I don't know. This could go either way, people.
That's
This could, he could just,
Some questions, it's just about the text.
he could
And
just,
what, just by way of proffer, what about the text?
Just to admit, so when other people asked about the text, some of them weren't in the record today, so I organized them. They're the ones that have been talked about today, so I just organized them. I just wanted for point of reference to have them. That's
Okay,
it.
okay. And do we need Mr. Bradley for that?
I don't believe so, but
Have you marked them?
yes,
Have you showed them to the state?
I gave a copy to the state, but so these
Mr.
are.
Bradley, just hang on just for 1 second, just to make sure.
I'll give you all of them.
Admitting all of them? Or not?
You can.
well, his next stop is to the Bar Association.
I don't object.
And I think it's fine. Yeah.
And while he's looking at that, Mr. Bradley handed me Defense Exhibit 23, 24, 25.
Judge, I didn't realize that they were in my folder.
Oh, is that from the hearing?
That
From on Friday? All right, well, Thanks for returning those.
Fine.
Uh,
The reason that was in it is because you
Let
were
me make sure.
Well, he kept some of the evidence from last Friday. He said he didn't realize
because
they
of your
were, he
objections,
had them.
front part and the back part of things. You have an objection to any of them, you can tell me, or you can admit.
Okay, so I've got 23, 24,
They still,
25.
still arguing.
Anything else in your binder? Or-
Now
Good.
she's organized.
Okay, and have we come to any conclusions on,
Yeah.
what, I'm sorry, how did you mark it?
I think we're up to 39. Surprisingly, the state objects.
All right, Defense Exhibit 39 is tendered and admitted without objection.
Well, no.
Oh, I'm sorry. Oh, okay.
Text messages that weren't referenced today with, or confronted, with,
Okay.
as it relates to Mr. Bradley.
So these are additional text messages, Ms. Merchant?
Yeah, so what I did was they objected that they weren't complete because like the first part of the text wasn't there. It was just
We'll look
like,
at
oh, there
this.
was something before
Everything in
that that was said.
context.
So what I did was I spent this whole time trying to line them up so that I had the beginning of the text, the middle, based on their objection. They have all the text. They can admit all of them
Yeah.
if they want them complete. And
All right,
Yeah.
how about, I'll just do this. Just, I understand the desire just to have the complete
Clean record.
text
Yeah.
chain,
I have a clean record.
just for purposes of completing the record.
But I tell you,
you know,
see,
I think
have a
that
clean record.
there's no point in having him sit here and authenticate every single one of them. So I'm willing to admit it as a
Stipulate.
court's exhibit. And only the exhibits, though, that had been previously tendered or referenced in testimony would be ones that actually are relied on for making any findings. But just so it's on the record, we have the complete text chain, should that ever be an issue for some reason. Any thoughts about that, Mr. Abadi?
My only thoughts are this is not the complete text chain. I'd look
Yeah.
to briefly look at Miss Merchant's phone when she allowed us to have it for
Okay.
seconds, minutes, and there are text messages I know that I saw that are not in what is purported to be State Exhibit 39. So
Okay,
it's not
all right,
complete
Ms.
text.
Merchant, what about that?
I let them take screenshots of them. He sent them to himself on my phone. I have also offered to
You
hook
said
my phone up
you're
to
supposed to have
whatever it
all
is.
of this
My phone's an
printed
iPhone.
out.
His is an Android.
just
I
give it
can't
out.
download like you could in a normal text. I told them if they
She's
had
gotta-
a system to get all of my texts, they can have every single one.
She
of them.
should
We
just
can
have,
definitely
she
do
should have
that.
already had this done.
Yeah, Mr. Rice.
You've
text
had,
that
this
she's
has been like
submitting now
weeks,
and
she's been
tendering
saying this
into
for 2
evidence.
weeks.
They are specific parts of the conversation. The entire text chain isn't a continuous conversation subject to Rule 601. Those particular parts, given the witness's testimony, should be admitted as substantive evidence to prior inconsistent statements with this testimony today. We got for the government, the state, if they then want to introduce the rest of it, have at it.
Yeah. Sure. I think that's a fair point that if he had been confronted with a particular text, that could have been the opportunity to admit it as a prior inconsistent statement for impeachment. And some of them were, but apparently some of them were not.
Taking those out. So it's gonna, I'm taking out the ones that they said he wasn't confronted with, and I'm just going to admit the ones that he was confronted with. That's fine. It just makes it more confusing, but it's fine.
It's confusing.
All right. So we have a
already.
newly marked, newly compiled 39. Let's see what the state thinks of that one.
All right. So this is what they're arguing about, is what evidence.
All right.
is going back
Regardless,
into the
if that's
judge.
now what is being discussed, again, I don't see a need for Mr. Bradley to be here any longer. So
Yeah. All right,
I'm going to
Bradley.
excuse him at this point. Thank you, Mr. Bradley.
Go to your
Judge, may we be-
disqualification
Of course. Take
on
care.
hearings.
Yes, that's right.
That man's law career is done. He should get the hell out of here and never be near a courtroom again. The defense strategized on what order to ask the questions. Could Shadow have gone first? I believe so, but this is actually Merchant's. The reason why Merchant goes first every time, because this was actually initially her motion. Because don't forget, he went to her. He went to Merchant and spilled all the beans. So that's why Merchant was the one that filed everything. So this is actually Merchant's hearing. They all joined to Merchant's hearing. So that's the reason why they let her go first. Even though she did a horrible job, I gotta say, because she should have had all those you have all that stuff ready, but she didn't have. She wasn't prepared for the day, and I think it hurt because when the judge is telling you it's time to get the hell out of here, that's not a good enough. But we're going to see what the judge says now. Is he going to disqualify? He may just say no right now. He can rule from the bench, or he can write something out.
But you didn't confront him with them.
When Ms. Cross had met the witness.
So let's see. I've seen judges do them both. He could be making that ruling right now, for all we know.
Yeah. Okay, so
So where are we with Defense Exhibit 39?
it might be helpful if you looked at them so you know what we're talking about, but I confronted him with all of
This
these.
is your, this is 26. You've already got it.
Right, I know. So
you're.
exhibit 26.
And the
I
problem
put
is
in
she was
so
so
that it made
bad
sense. So you could read it. You know, when you're reading a
that when
text,
you
and it's a
had
conversation,
Sure.
Shadow
They're
come up there
upset that-
to lay it all out.
they're not in order now, I guess. I don't really understand, but if you want to look at them, you can.
Well, let's start from the beginning. What is the purpose of Defense Exhibit 39?
These are the ones that I showed him and that I showed him today. So there were a lot of follow-up questions on it. And so I realized, okay, well, they should just be in the record because other people are referring to my texts and they might as well just be in the record. And he authenticated all of them.
All right.
So
All right.
And Mr. Rice?
Not just in the record, Judge, they should be admitted as substantive evidence because they permit prior inconsistent statements.
Okay. All right. So to that end, Mr. Abadi, is there a particular text message in there you think was not authenticated? I understand you're saying, well, maybe one of them's already been admitted. So, but otherwise, just having a omnibus, here are all the relevant text messages exhibit. Is there an authentication objection? Is there any other kind of objection like that?
Yes, because he didn't authenticate that all of the text messages were from him and between Ms. Merchant or the context of them. So I think that's the problem when you don't, if, for example, if the state was to provide, I guess, just a specific text chain from a cell phone extraction, there would be an objection because the state would be making the determination as to what is relevant. Really, all the information should be turned over, and it's for the parties to object and Your Honor to determine which parts of the conversation are relevant or not. I don't have all of the conversation. The conversation starts in September, and then so there's a few text messages from September, and then we jump.
Now
to
this
January.
is Merchant's fault.
Ms. Merchant has
They should have
determined that
already had
that
all
jump
the.
in between.
You
is
give
not
them
relevant.
everything
That's-
already.
That's not
right?
appropriate. It's for Your Honor to determine what's relevant and not. And I can't make an objection as to what I don't know. I can tell you what I've read. It seems as if there are definitely parts that are missing that would make certain parts of the text message she's attempting to admit that she didn't confront the witness with would be my objection. But only the relevance can only be determined if we have the full chain. So she's determined which ones are relevant. That's your job.
Sure. So didn't she just try to do the full chain as an exhibit just a moment ago?
She
No,
did.
We don't have the full chain. The full chain is text messages that begin in September and continue down. That's not contained in that entire package. They're on her phone.
Okay.
She'd like us to do an extraction of just that chain.
All
We
right,
have to do
Ms. Merchant,
technology.
and then Mr. Gillum.
not a problem. And I offered that when we were here before and I was told they didn't have that technology. But let me just go through them one by one. It might be easier. I was trying to just do it quickly all
You
together.
can just hand them to me.
So the first,
Just hand them to me. I can
How
read
did
them.
you not do
And
this
Mr.
2
and
weeks ago? You should have.
While I'm
they
reading
should
them,
have
Mr.
all been
Gillen, what did you have
printed
to
out
add?
And given
Quick
over.
point, Your Honor. Apparently, this merchant has allowed the state to take screenshots of what they now contend would be the larger perspective on, and I disagree with them about the rule of completeness, but it's their job when something is admitted that if they have an objection because the context is not appropriate, they then move. And the state should move the rule of completeness, the admissibility of the other emails chains that they had. So the real issue here is their failure to comply with the rule of completeness once they have the material from the last hearing that they took screenshots of.
Well, isn't that what he's doing now? Because now they're being tendered?
That's true, yeah.
I don't think that he is. I mean, it seemed to me that what was happening here is this Ms. Merchant has tried several different ways to get it in. She wanted everything in and they objected to that. And she wanted the segments in that had been
Authenticated.
the witness had been asked about, and that's what she's trying to do. My point is that if they're at the time of frankly of moving under the rule of completeness is at the time of the tendering. If they want to tender something to show that it should be included to be complete, that's on them,
Sure.
not on this merchant.
All right, Mr. Abadi, last point here.
So I had a very limited time with Miss Merchant's cell phone. I only had time to literally find one part of the text message to then send to myself before Miss Merchant demanded her phone back. So I did not have the opportunity to screenshot every act or every missing part of the conversation to then do as Mr. Gillum is saying that should be done, but it can't be done if I don't have the information. So you don't have the complete packet, and there are many of the text message screenshots that you have printed out that were not used to confront Mr. Bradley or refresh his recollection. So they're inadmissible evidence. If anyone missed the opportunity, it was the defense counsel
Sure.
to confront him.
All right. I don't think we need to go back and forth any further. Ms. Merchant, you've offered, you said, to print out a complete chain of every text exchange with Mr. Bradley since you began corresponding with him. I'll give you a
has
chance to
them.
do that, and you can follow up by email with that exhibit. It would be the complete chain without any
So I don't think he's going to be
deletions
ruling
or
today
removals,
because
and we'll have that marked as Defense Exhibit 39.
he's asking for.
Judge, I
And-
have got to
So he may
respond
not rule to
though.
us.
In
How do you have
court
to
There you go.
respond?
Friday
You've
at
won. You've gotten them in.
1:57, when Mr. Abadi texted himself the screenshots, I literally wrote him,
She
do you want
said,
any other screenshots?
put
I
them
have nothing
in.
to
Why
hide,
do you
can
have
download my phone
to?
if you want.
You've
So,
won.
I-
She's won.
All
He
right,
said-
we're done.
Yeah.
Okay, so I'll
But she's
wait
still
back to hear
arguing.
from
You
y'all on
won.
Exhibit 39.
What's
And
wrong with her? She like you won. Oh, I don't want to
is
still
there
say
anything
something.
else to take up
What?
before we discuss Friday? Just kind of throwing it open to the floor. Seeing none, I believe I'd asked and put it out there among defense counsel to be considering how they would like to organize their arguments on Friday. Has there
Friday,
been
we're coming
any
back Friday.
decisions reached on that?
To determine that,
Okay.
and I can email the court when we're done with that, but we are going to make it as efficient as possible and break it up.
Break it up in terms of like subject matter or something like that?
There's time limits.
Yeah.
That's large.
Yeah,
Let
that's
us know.
that's the
Yeah,
idea.
her questions did ruin it.
Tell us what that
Because they
means.
couldn't ask because you asked and answered.
Well, I'll start with, what is it that you're asking for? And we'll start there. It's kind of curious.
They don't
Well, I
want Bruce to
think
go
answer
first
that
again.
right now. Number one, the court said, look, if you divide it up, then we can go with that. Or if you can't divide it up, then I'll give each defense counsel a specific period of time. Tomorrow, we'll find out when we meet whether or not we can divide it up in a way that serves the interest of our respective clients. Hopefully we can. We can communicate with the court.
Okay, I'll just wait to hear from you. To the point of, I think the state recently filed their own motion to, I think it formally said to reopen the evidence as to another witness. I only got to read it very briefly,
State wants to bring
or I don't know if
somebody
that was
else
just saying in the alternative, we'd like to reopen the evidence. I don't know, maybe someone can clarify that, but my thought
in. I don't know.
there and what I think we ought to do Friday and what I would like to do on the issue of the cell phone analysis and this other affidavit filed by the state today is that both parties, any party rather, can make whatever arguments they want based on a proffer, any counter arguments they want to make based on a proffer. They would not be admitted into evidence at this point. And at this point, I need to start hearing the arguments in the law and what we've heard so far. And if I think I'm able to reach a ruling based on that, I will. However, if I think that the proffer is going to make a material determinative point, we can reopen the evidence at that point. But just the bottom line is on Friday, I do, the intention is that we're still sticking with argument. But the parties are free to address some of these issues that have been brought
All
up
right.
post
In other
hearing
words,
if they'd
it
like
seems
to.
like Friday's going to be the end
Your
of
Honor,
this thing.
excuse me.
Uh-oh.
Sorry.
Let me start with Mr. Sato.
Say now.
I'm alive and well with a quick question.
All right.
That suggests that we do not have to have a witness present on Friday for the cell phone record, correct?
That's right. Friday would just be argument, and counsel can
Say that
offer
was
why
to
they
bring
think
the
it's
cell phone
significant.
records.
And if once I've heard the law and the argument of counsel, I decide that that is going to have some material bearing on the outcome, then we can reopen the evidence and have it properly admitted and authenticated and subject to cross-examination.
Thank you.
So they want to get the
Okay.
cell phone evidence
Merchant.
in, that the one that was
I
just
just wanted to know
yeah,
if the
just
court
hit the
wanted us
thing.
to focus our arguments on anything in particular. Any questions we wanted us to try and answer?
Well, actually, I think what I'm more likely to do is more along the lines of what I suggested before, is give you all a time block and you use the time however you think is more effective. What you think is your strongest argument. I don't, a lot has been covered, and there's a lot in the motions that weren't covered during the evidentiary hearing that I would plan to rule on at the same time as well. So I leave that to you. Mr. Gillen?
Thank you, Your Honor. I know we have other motions to hear on Friday.
Oh, we do?
I thought we did.
I just said disqualification as a whole. So if you have arguments about forensic misconduct, about anything like that, that would be the time for that argument as well.
I consider that part of the disqualification.
Sure.
I thought we had scheduled hearings on the murder.
No, I mean, I talked about that and then things evolved. So we didn't actually send out a notice adding any other motions, but we do need to. We have some trials starting next week. The next 2 weeks, we've got some of our homicide trials already scheduled. So I'm going to be following up with y'all to schedule the rest of the pretrial motions that we have.
Yeah, they're trying to finish this up.
We have on Friday, it'd be 1 o'clock on the issue of disqualification.
That's right. All things disqualification.
That's it.
Anything from the state or any other defense counsel?
Damn, this took so long.
All right. Thank y'all. All right. We're off the record.
Woo. All right. That's it. Finally. So let me stop this. So this is the off the record tab because they shut the Zoom down. So this everybody's leaving. All right. So this seems to be the end of this issue. Cameras off, Zoom's off, everything is off. All right. So we now have to wait till Friday. So Friday is closing arguments. Now, if you guys didn't know what happened at the end, remember you guys have heard all that, the wranglings out there. I don't know. I just did a video about it, about the cell phone records and things that have come into nature. So the defense sent a subpoena to their cell phone companies and got back all the cell phone data about like Fani, like Wade sleeping over Fani's house overnight and all that other stuff. So they want to get that in because they're saying that that is relevant to the disqualification when the relationship started. So as of right now, the judge is saying, well, we'll see. We'll take that up on Friday. So on Friday, what you're going to see, Steve Shadow, he's going to have the investigator there at the courthouse just in case they can reopen up the evidence piece of this and introduce this new evidence to the judge, because you have to have somebody authenticated, what to say, and all that type of stuff. And then you're going to have back and forth question to it. So he said he'll decide that. So remember all that cell phone evidence? There was one about the GPS tracking, the 12,000 text messages and 2,000 phone calls. That is all going to be taken care of Friday. So as of right now, where are we at? So we didn't get a clear answer to our question because he kept saying he doesn't recall. Now, the question was, before November 2021, did you know that Fani Willis and Nathan Wade were in a relationship? He said everything from I don't recall, I don't know, blah, 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 blah. Every single answer was that he did not know or couldn't remember or something like that. But in contrast, he wrote merchant and text messages saying he knew they were in a relationship. He wrote an email saying that he knew about the relationship. He made phone calls telling her he knew about the relationship. And then on top of that, she sent him the document that she was going to file in court. She said, here's the document. Check it to make sure it's all right. He checked it so well that he checked the footnotes. And one of the footnotes, it was like his salary was wrong. They changed his footnote. Checked it all, and then gave it back, sent it back to her and said, hey, everything but that footnote, change the footnote, and it's all good. And she filed it because he told her it was all good. So that is where we're at. Is he now lying or not, based on what we know? Now, I think it's obvious that he's not telling the truth. He's lying. Now, why would he want to lie? Well, don't forget, this is the DA's office. And he's essentially admitted to multiple issues with SA. He's admitted to issues with perjury. He's got a lot of issues that he could be, he's got a lot of issues. He's got a lot of issues. So obviously he wants to try to maybe tone down the heat off the DA's office. So that's why he's saying he don't know. Even though the DA's office is the one that threw him under the bus. But then second, I think his career is done. As we've been talking about before, his career essentially is over, right? He's given up his client's confidence. He's broken almost every ethical rule. So again, he's pretty much done as a lawyer. So I'm thinking he's just trying to save whatever he can. I think he's figured out Terrence Bradley, Wade's former defense attorney. I'm thinking he realizes that the only way out for him is to try to stay as good as he can with Wade and Willis, and and forget about the Trump team. Now the problem is that he's the one that went to the Trump team to give him all this information. So I think he's kind of just he's in a tough position, but he created this position on of himself. So now, for you guys out there who's trying to judge, what do you think the judge should do? The only way you can really get to disqualification is by proving that Willis in some way was financially benefiting off this. That's the only way you really get to that disqualification. Can you prove that? And the only way you can prove that is show that she got, number one, you got to show that she actually got gifts and money and cash and all that. We got that, right? Wade says he took the trips. There's credit card receipts about the trips. There's credit card receipts that he paid for the trips. So that's not the case. Whether he did all that, whether he paid for all that, we got that check. Number one, she got benefits and he paid for it. Number two, did those benefits come from him working at the DA's office? We know that. Why? Because he made something like $600,000. That was his main source of income at that time. So we got two things. We know number one, she got these trips and vacations from the documentary evidence. And number two is that his main source of income was from the DA's office. So we got two of the three. Yes, she was getting gifts. Yes, it was money from that he got from the DA's office. But now the third thing is that did he pay her back? Because if he paid her back, the case is over. Now, the reason why we're here today is because they don't have any receipts. If they had a receipt, we wouldn't be here. It would be over. We'd be done. Because we'd be like, oh, there's a receipt. He paid it back. There's no disqualification. It would essentially be over. The receipts for those trips, if she was able to show receipts, this would be over. But they can't show any receipts. The only thing they can show is that, take me at my good word, I paid them back in cash. So without any receipts and just saying I paid them back in cash, that's where these other issues come in. Because now, how can I trust you? How can I trust, of course, you're the DA and you're the, her chief lead counsel in this, but how can I trust what you're saying? So that's where you have the credibility game starts being played. Now, the defendants here are saying, well, your credibility is shot because we have all these witnesses that saying what you said is not true. We have live witnesses. Here are some of these live witnesses. We have two live witnesses that are saying the relationship started earlier and that you guys are lying in court. That's essentially what the defense has. And those two witnesses were, here, I'll put her up on the screen. This is Fani's this is her, Fani Willis's former best friend, the one who let her move into her co-op back in 2019. She says Fani Willis, Nathan Wade relationship started in 2019. And it was funny because we were calling her 2 Chainz because of the change from her glasses. But that's what she was saying initially. And now this woman doesn't really have anything to lose. She didn't want to be there, but that's what she said. She said the relationship started in 2019. He said the relationship started before that, 2019, 2018. He's saying it started long before that, right? Even though he's trying not to say it, that's what he's saying. So now Wade and Willis are saying, no, they are both wrong. They are both lying. They are both mistaken. It started in 2022. So this now comes down to the ultimate question of credibility. Just who's telling the truth? Who's telling the truth? Is it Wade and Willis? Are they telling the truth? The relationship started in 2022, or is it the other two? Now, if Wade and Willis have been found to be perjuring themselves, to be lying, then you start this chain of reasoning of why are they lying? Well, obviously, to keep their relationship a secret, to make it seem less likely that they were for her to be disqualified. So if that's the case, then you would punish them for that lie, right? We're going to disqualify you and punish you for the lie. That's essentially what was going to happen. And your credibility is shot because I can't believe you because I've caught you in a provable lie. Now, if they aren't lying, then the case is over. And generally the case would be over if the judge, if you weren't going through this when the relationship started stuff, this case would technically be over because there's no evidence to show that she didn't pay anybody back. And there's no evidence to say she did, right? So tie goes to the runner. You can't just not trust her. She said, I paid her back. I'm an attorney. I'm in good state. I'm a law enforcement officer. Believe what I say. Then the judge is going to take her word for it unless you had some conflicting evidence. But right now, he can't do that. Now he has evidence to show that she may have been lying, her and Wade. So that's where we're at now. Are they lying when they said the relationship started in 2022? Or are they telling the truth? Are they telling the truth? Now, my personal opinion, I think they're both lying. I don't think, now, the reason why, think about motivations. They have the extremely high motives to lie, right? Let's just keep it real. They have extremely high motives to lie. But what's this woman's motive to lie? Her and yes, she left the DA's office years ago, right? Her and Fani are not friends anymore. Fani said she was a friend, and so she testified that now she what did she say? She said she betrayed her. But also, this woman tried not to be here, right? This woman tried not to be here. She didn't want to testify. She had our lawyers tell her not to testify, but she still testified. But then they subpoenaed her and forced her to testify. So she seems credible to me. This guy obviously does not seem credible. He just doesn't. But there's a lot going on with this guy, right? He's lying. He knows. He doesn't know. The question of did he know the relationship was before 2022? I think he did, and I think he's lying when he's trying to pretend he doesn't. And I think the judge knows that he knows the relationship started between us. So if that's the case, then it seems like Willis and Wade were lying too. Who carries that much cash without bank storage? Hey, Willis did. So, that's essentially this ballgame. So Friday, we're going to know from this judge if he believes that these two people, the sitting district attorney and her top prosecutor, are credible. And that's what he's going to. And the other side has her best friend and this attorney who everybody knows is a scumbag who should be disbarred. It's tough because it's really how do you gauge this guy? I don't believe anything this guy says. So, is a judge going to believe him? Is a judge, and what about all those text messages? There's so much there. But I believe at the end of the day, I just want to be very, very clear what I believe. I believe he knows, and that's why doing this. I think his text messages were true, that Wade and Willis had a relationship from before. I think this witness, I believe what she said is true, Willis and Wade. And I believe Willis and Wade are trying to protect their prosecution by saying it started after 2022, which I think is a lie that didn't need to be told. Because if you say it started before or after, it doesn't matter. You can say we had a relationship before, even after. But if you still say you paid it back, then this takes this off the table. So I think they lied, and that lie is putting them more in jeopardy. So with that said, I think this is 50-50. I honestly think I think the judge can come up and say, well, you're saying they're lying, but I really don't know if they're lying or if we think they're lying or when the relationship started. Just because you're begging someone doesn't mean you're in a relationship with them. Who really knows what the judge can say? But I think there's just enough here. But I think the judge can say, yeah, it's 50-50. Tie goes to the runner. She'll stay on the case. But I also think there's a lot of fire here to say, you know what? Because the appearance of impropriety is so strong here, we're going to send this to someone else, right? It just makes it easier for it to do that. So with that said, let me see if there's any questions in the chat that I can go over real quick. Damn, Nate, your stream popping off at over. Oh, thanks. Yeah. No, we have more, but my power went out because we had some storms down here. So my power went out. So I lost like 4,000 people, but it's still fine. No, I'm glad for the people who stayed. Thank you for the people who stayed. Did Fani dad carry that much cash in South Africa? I don't know. Remember, he called COVID back in 2018. So 50-50. Now I don't know what to think, Nate. But if anybody's telling you it's obvious that he's gonna bounce them, I just don't think you have that. Well, it all depends on whether he lets his cell phone data and all that stuff. Because I think if you get to the point where I think he could definitively the judge is looking for something to hang his hat on. Don't forget the judge still got to work there too. So the judge is looking for something to hang his hat on. I think they definitively lied when they said blah, 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 and then it's over. So I think that'll be the question. Sex ain't a relationship. No, you can have sex without having a relationship. How was their relationship initially discovered? Because this guy told Trump's team that they had the relationship. So that's how it was discovered. He ratted them out. He ratted out his best friend. So, thank you, Charles. That's how all this happened. BS meter off the charts. Yes. He's full of crap. Thank you for the $1.25. Yes. The woman's real useless. I would say this. I think Ashley Merchant's today, I don't think she came prepared. I don't think she came prepared at all. I think what she did, her questions were just horrible. It's like one of those things where I think she knew what she wanted to say, but she just didn't know how to execute it. And as you can see, Sadow came in and he was executing. He was like boom, 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 boom. But he kept getting stopped up because they were like, she asked that question. But the way he was asking it was leading to an answer. The way she was asking it was just like, it's all happening. And as you see, she wasn't even prepared with the documents, right? If you think that if you're asking specifically about stuff that he's already said, and he's lying already, you should have that stuff ready. When you said blah, 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 he's like, I don't know what I said. Here it is. You should, but she didn't have all that. And like she said, she was spending the second half of the hearing getting her paperwork together. So you should have had that, and even for the fact, this last little piece that we spent like another 15 minutes about. 15 minutes about whether you turn over all the text messages or ones that she just thought was relevant. That should have been done weeks ago. She should have downloaded all her text messages, whichever way you can do it, right? If you have to have somebody screenshot them all, put it in an Excel spreadsheet, print them out, and then send them to everybody. Here's all the text messages, and these are the ones we're going to talk about. And then you don't have this issue about whether they're complete, whether they're not complete. Everybody's got them. This is the whole thing. But I'm assuming, she still handed people her phone. Look at my phone. The text messages on my phone. No. Print them all out, put them in a nice little thing, put them in a spreadsheet, and send them off. There it is, right? But it doesn't seem like she wanted to do that. She wanted to do this thing the hard way, and now they're still looking at text messages from. So I just don't know what's up with Merchant. Even though she's got us here, people, Merchant is the one that got us here. So don't knock her too much. She got us here. We're at the table because of Merchant. Merchant's investigation, the fact that this guy, I think he wanted to bang Merchant. I think this guy wanted to bang her. And I think that's what got us here. She talks Merchant. He gave Merchant everything. And I'm thinking he's looking at that pretty face and was like, hey, listen, I'll tell you whatever you want to know. My client secrets, boom. Attorney-client privilege, boom. Confidential information, boom. I'm telling it all to you. And I'm thinking that's how Merchant was able to get the information and get this thing going. So let's just be clear. Merchant is the reason why we're even at the table. So you got to give her credit. She rolled those stuff up. She investigated. She did her job. I think today was a bad day for her, though. What about Wade's cell phone locations? Well, now that's what they're talking about. So that may happen on Friday. On Friday, what the court is going to do is say that cell phone location data and those cell phone records, we got to do two things. One, we got to authenticate that they're true and accurate copies or whatever, blah, blah, blah. After we do that, then you can have the investigator sit there and talk about what it all means. And then he can be cross-examined by the state to say, well, does this really mean what you say it means? Blah, 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 blah. So that's where you get with that. And then the judge, before even seeing that, has to determine whether that's going to affect his ruling or not. Because if he says, that's irrelevant to this, and I'm just going to do it, then that would make it sense. But I would suspect 2,000 phone calls and 12,000 text messages, either you're in a relationship or this is as close as a friendship you're going to get. Like, just imagine if you're married and your wife, and this is the woman you're texting 12,000 times over, and you texted 12,000 times and called her 2,000 times. Matter of fact, I don't think I called anybody 2,000 times in a year, talking about a 6-month period. So yeah, obviously, just I think it doesn't pass the smell test, but we'll see if they can get it in, because now it all depends on the judge getting it in. Thank you. Thanks, Tim, for the $1.99. I appreciate it. And again, sorry, I got to cut that piece out the middle of the stream. So I don't want to lose the live chats. You know what I might do? I might put like what's it called? A timestamp there so people know when the stream went down. Nate the lawyer, they seriously dropped the ball asking about the backroom conversation. That'd have been the first question I asked. What was the conversation in the back room that you had, blah, 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 that you said were privileged, right? That's the question we want to get to. That's the question we want to get to. But nobody asked that question. I don't know why nobody asked that question, because that's what the judge said was not privileged. He said it was privileged. The judge said it was not privileged. We don't even know what the hell was said back there. But like, what did he tell you back there? Why'd you say it was privileged? That type of thing. But we didn't get there. I'm surprised they didn't call Wade's ex-wife as a witness. Interesting. But then you'd have to ask her, when did she find out about the relationship? Right? You'd have to, because when did she find out? And I'm assuming, did she know before? Did she know after? And don't forget though, the the interrogatories that Wade signed under penalty of perjury said that he didn't cheat on it too. So, Nick, call your mom 2,000 times in what, in a 1 year period? I don't even think I make 2,000 phone calls in a year. 2,000 phone calls in a year? What's that? Something like, well, 10 a day is just 3,000, 3,600. So you're talking about what? 5 phone calls a day? I don't think I make 5 phone calls a day. I don't know if I make that many phone calls a week. Like just calling people. That's a lot. That's a lot of phone calls per day. And you're talking about 2,000. not sure I've made 2,000 in my lifetime. And then 12,000. And again, with some woman who you're not having any type of relationship with, I don't know. That's a lot. That's a lot. That's a lot. But again, it's all up to this judge. Well, listen, people, I want to thank you guys for showing up. I hope this was fun. We'll be back here on Friday. But now, for those of you who are still here, I actually have a huge surprise. For those of you who've been following the Tiffany A. Hinyard story, I have a surprise this Friday. I will have in studio someone from Dalton, Illinois. Now, let me just stop. I'm interviewing Mr. House. He is the lead trustee in the fight against Tiffany A. Hinyard. Yes, I am interviewing that guy. He will be here, and we are going to be talking everything Tiffany Hinyard. We're going to talk about why he, at one point, endorsed her for mayor. We're going to be talking about all the craziness that happens here. So he will be here, and we will be talking to, I believe his name is Jordan House. Let me show you who he is from Dalton. But he is the lead trustee in the infamous Tiffany A. Hinyard issue. So let me go to Dalton trustees. He's known as I think the senior trustee, but let me show you who he is. Here we go. So this guy holding the mic, let me share this one. Let me share this tab so you can see who I'm talking about. So this is the Dalton trustees, and let me do this, and this is the guy. So yes, he will be here Friday, and we're going to be interviewing him about the whole super mayor. Watch out for the drive, bro. Hinyard is on the prowl. I get shot up, right? No. He's not going to be in studio, but we're going to be talking, I think, over StreamYard. Could you look into the Brent? I will actually look into that. Shop and somebody else told me that too, so it's on my list. Nate the Lawyer, check out Locals. Check out Nate the Lawyer on Locals and Patreon. Thank you, Op-Ed Fred. Don't forget to check us out on Locals and Patreon. So he will be here. House will be here. And we are going to be talking everything Tiffany Hinyard. So you're going to see it. We're going to ask all those questions. And with that said, let me get out of here. I will see you guys Friday for the rest of this, and I'll also see you Friday for the meeting with House. So with all that said, don't forget, like, share, subscribe, do like that YouTube stuff. My name is Nate the Lawyer, and I'm going to see you on the next one. Peace.